Yes.
My lord, may I be permitted to mention one matter for inclusion in the list?
What is the matter?
Order 41, Rule 11.
When we sit in division bench, then mention. Division bench matters, mention when we sit in division. Yes.
My lord, I'm praying leave, my lord. My lord, the judgment was passed on 17/1/2025, my lord, in AP number 2022-29.
What are you seeking now?
2024. I'm praying leave to my lord. Kindly direct the department to draw up and complete the judgment.
It will appear as to be mentioned. Please hand over a slip. Yes, any other mentioning? Call on the list.
For the official.
Yes.
Number 1, my lord, this is for correction of your lordship's order, which lordship had.
Please use the microphone, ma'am.
Sorry, lordship. Now, this is your lordship's order dated 17th of January 2025.
Yes, what is the correction?
My lord, at page number 1, my
Yes.
lord, the first paragraph, my lord, land situated in Mysuru. My lord, the same correction also at, my lord, page 10, your lordship's order,
Yes.
Mysuru. 7th line from the top, my lord.
Yes, it should be at Dankuni.
Dankuni.
Dankuni already.
Providing the full.
In the order dated January 17, 2025, comma, in the third line of the first paragraph and in the 7th line of the 10th page, comma, the expression Mysuru within double inverted shall be read as Dankuni. Double inverted mode. Full stop. Let this order be deemed to be a part of the order dated January 17, 2025.
Lord, it'll be Shridampur. We've given the particulars of the land.
আচ্ছা মাইসুরের জায়গায় তাহলে ডানকুনি যেখানে বললাম না করে ডানকুনি জায়গাটা এটা ঢুকবে এটা এটা জাস্ট কপি পেস্ট যেখানে ডানকুনি বললাম তারপর উইল পুট দ্যাট
I'm grateful.
নেক্সট হ্যাঁ পুরোটা
For the alleged contender number 1.
What is the content?
Well, Mr. Ghosh, Shanlendu Ghosh is appearing in this matter, my lord.
Yes.
Your lordship may recall that last Friday he mentioned the matter when your lordship was pleased to direct the matter that to appear in the list as scheduled. Therefore, today the matter has been...
You are to ask for time. Well, you are for the petitioner.
I'll got the petitioner.
So we'll grant time till next Friday. On the prayer of the petitioner,
my lord, one thing, affidavit service is ready, my lord.
We'll take it on. On the prayer of the petitioner, the battery is adjourned till February 21.
Next week, my lord.
February 21, 2025. Full stop. The affidavit of service filed to be kept on record. Next week is 21st.
Yes, my lord. Deeply good.
Next. Yes.
Well, I appear for the alleged contemner.
What happened to the appeal? There was an appeal.
Item number 5 was not reached last Wednesday. Today again it's appearing in the list.
It's appearing today?
Yes, again it's appearing in the list of the Honorable the Chief Justice.
Next Friday.
Could you keep it 1 week thereafter because so that I don't embarrass your lordship.
No question. Since the connected appeal is still pending before the division bench and is appearing fairly up in the list, comma, on the prayer of the learned advocate general, the matter is adjourned. Learned advocate general appearing for the alleged contemner, comma, the matter is adjourned till February 28, 2025.
I'm grateful. But I hope, my lord, by that time it's...
We also hope so.
And for the official liquidator.
Lord, this is my application.
Last occasion, there was a direction for filing a report, my lord.
Report, yes, joint.
And the joint valuers, they are present, my lord, with the report. So can we take...
Let us have the report, yes.
And may I file the report?
Rejoinder?
This is not actually a rejoinder. This is just a report in the form of an affidavit, my lord, of the official liquidator, indicating the security expenses and the legal expenses. And there was a specific direction.
Have you circulated copies of this among the parties?
Yes, my lord. But they have held a meeting.
Here for the security guard.
Yes, obvious.
But we have, there was a meeting held, my lord, but there, because of the divergent views, that it cannot be resolved with regard to the security expenses. And with regard to the legal expenses, they have assured the official liquidator that they will not stand in the way.
They means
But
Mr. Ghosh.
yes, the
Yes, yes, yes.
My client.
contributory.
My lord, with regards to the valuation, my lord,
Yes, we
we'll
require
have
the
to have a
report
look
of the valuer. What is that?
তাও
দিন
value-
ওটা খুলে রিপোর্টটা খুলে এইটা রিপোর্ট আছে yes have you got a copy of the report Mr. Ghosh?
My lord, we have got a
Your voice is
report,
getting
but
disrupted. Your voice is getting
it
disrupted.
doesn't specify the values. So unless we have a
Mr.
specify
Ghosh,
the values,
your
what
voice
the
is getting
actual
disrupted.
valuation of the land?
Your
I'm sorry,
voice
my
is
lord, I'll
getting
just switch to
disrupted.
a
There's
separate connection.
an issue.
There's a lag.
Repeat.
My lord, they have filed the report. We have a copy of it, but the
Yes.
value of the properties are not indicated in the report which have been given to us. So we need to, because it was in sealed cover, what has been filed before your lordship is
Even an
not exactly
unpriced
the
valuation report
which is-
circulated, my lord. Even I have got the unpriced one, and the main valuation report is before your lordship, and they have indicated
The valuation report, yes, the main valuation report is with us, with me. It has been filed today, so that copy has to
Yes,
be given
my
to them.
No,
They
yes,
should have
my
a say
lord.
on
That is
that.
what I'm praying.
That they can make an inspection if they want, my lord. Let it be with the assistant registrar company.
So why not a copy be given to them?
No, they've already given us a
If
copy
your
of the
lordship so
valuation.
directs, then it can be circulated.
The joint
circulate.
report on valuation
Leave the
filed
value.
today be kept on record. Full stop. The sealed cover containing the same is opened by the direction of the court. Full stop. A copy thereof be circulated among the unserved parties by February 17, 2025. Full stop. The matter be listed for orders on February 21st,
Let there be a
2025.
direction upon the official liquidator to have an access over this valuation report, because we are also having an unpriced valuation report. So this is the
No,
original one. So
I've said circulated among the party, among the unserved parties. So you'll also get a copy.
No, only
No,
one
to
thing
have
may I
it.
just indicate, my lord.
Yes.
Pursuant to your lordship's order, my lord, official liquidator has called for, my lord, the dues, my lord. As for, my lord, on January, my lord, I have given the bills to the official liquidator up to December 2024, my lord. In February, my lord, on 7th of February, the month of January bills were due, my lord, that has been indicated. Probably that is not my lord, covering within the reports of, my lord, the official liquidator. I have given him the, my lord, the letter in giving my bills for on 7th of February.
So this will go on if you forestall the matter, if you postpone the matter for that. At least let us see what we can do till January. I mean.
Lord, may
We
I
After
have
line add for them,
indicated
and a
in
copy of the
paragraph
report be
8 of
kept
the
on record.
report, my lord,
Pardon?
that why it has not been indicated, because they are not admitting the dues of the security guards, my
We'll
lord.
consider that at the time of
Yes,
disposal.
but,
Yes.
only one thing, my lord. Mr.
Can-
Ghosh said he's not available on the 21st of February, my lord.
21st you are not available. Then we'll
No, my lord,
28th.
28th, my lord.
21st over the
Yes, my
28th. The
lord.
next returnability is
Grateful, my lord.
28th. Please come back on 28th. We'll let you.
Clear. 4 and 5 to be taken up together.
Grateful,
4
my
and
lord.
5, yes. Same order in 4 and 5. Joint order. Yes.
I appear on behalf of the. My lord, on the last occasion, I was placing before my lord the application which was filed by OL, in which orders were passed by this court by Justice Sinha,
Yes.
which is my learned friend was addressing about, and for which he had indicated, my learned friend had indicated that needs to be revisited or clarified. Now, my lord would come to my learned friend's application at page 119.
Yes.
Mrs. Sikdar, learned advocate, appears on behalf of the office.
119, this is CA 27. What is the application number?
CA 27 of 2020.
119 is the second page of an order.
Right,
This is Shamadhar's order.
no, it would be Justice, the next page, my lord, would be Justice Arindam Sinha's order.
Yes, 120 in my copy. Yes.
The first paragraph is the application for letter for direction for
Yes.
prayer of declaration that so and so. Mrs. Sikdar, the learned advocate, appears on behalf of the office and refers to an affidavit of service filed and subsequently handed up track records to show both owner and the purchaser mentioned in the indenture dated 19th have been served. My lord, the issue was whether Mrs. Chaudhary, who had transferred the property to my learned friend's client, had received notice or not. There was a notice which was given by the official liquidator, and due service was done to the, and which is recorded here. Which is the subject matter of the instant flat. My lord, I had requested for a production of CA 266 of.
Yes, check. Yes, it has come.
My lord would come to page 8 of the CA.
Yes, please.
Page 8.
Page 8, yes.
This is written by Rajat Reality, Sri Rajat Enterprises. And Rajat Enterprises, who had transferred the property, the developer who had transferred the property originally to Mrs. Chaudhary. When OL writes to Rajat developers asking what had transpired, Rajat developers in turn give information to the OL how the whole transaction had taken place, including a copy of the registered deed of conveyance, which is item number 6.
Right, right.
First is letter of allotment. Second is letter of possession. Third is letter of from Lakshmi Narayan Udyog Limited, the company in liquidation. Fourth is the board resolution. All which now, my lord, I'm going to take my lord through. The next page, my lord.
Yes.
On an application made by me, us, you have been pleased to allot us all that open terrace having built up area of so and so for a consideration of so and so. And on the terms contained in the allotment letter dated so and so and the annexure thereof.
Who signed as the authorized signatory of the company? It was in liquidation then.
It was in liquidation. But the liquidation order on that day has not been passed, my lord. The company and its directors were, the application for liquidation is pending, but the liquidation order was passed on 9th April 2015. The last line of that first paragraph is very important. For the consideration and the terms contained in the allotment letter dated and the annexure thereof. We have paid the total consideration of sum of rupees 21 lakhs. This is, now my lord would come, now turn over the page. It's the same letter, but that the previous letter was for open terrace.
Oh,
and this is for the flat along with the car parking space.
Right, right. Yes.
For the consideration of 1,04,70,104 and the terms contained in the allotment letter so and so, and we have paid the total consideration amount of so and so.
Yes.
This, when we add up together, this is what the balance sheet. There is a difference of 1 lakh of rupees which we are unable to explain. Either the director or the official liquidator would be able to understand when the audited account, but today it's not possible for me to explain why there is a difference, but there is a difference between the total sum which we, with these two letters and the balance sheet figure,
Hmm.
which we had shown to my lord on the previous occasion.
That is more or less.
More or less, there is a difference of ₹1,00,000, which
No, which is more? That.
the balance sheet
Balance
figure
sheet.
is more.
All right.
My lord would now come to page 13.
Yes.
This is a resolution which has been passed by the company in liquidation.
Hmm.
After the company in liquidation was in winding up petition was pending. I had shown on the previous occasion the order which was passed at the on the undertaking given by whether it's senior counsel appearing on behalf of the company in liquidation, whether the factum thereof, whether the undertaking was in violation thereof, what was the fate, my lord would examine. But this is what the order was dated. August 2014. In my compilation at page 60, all through the
1st August 2014. Yes.
1st August 2014.
Before
Also-
this. Yes.
Although the counsel for petitioning creditor seeks an order of injunction restraining the company from dealing with, disposing of, alienating, or creating third-party interest. In respect of its assets, the prayer is opposed by the company, and on instruction, it is submitted that no step is being taken to deal with, dispose of, alienate, encumber, or part with the possession of its assets and properties. There's a clear statement by the, and on instructions. As far as I understand, my lord, that this is an undertaking which has been given by the company in winding up
Yes.
through its directors, which was what was recorded in the order. Anything done in violation of the orders of the court, as my lord knows, is non-est. I had shown my lord the conveyance
Mm-hmm.
that from page 8 of the application CA 226.
Hmm.
Now, my lord would come to my learned friend's application at page 34, maybe it's 35.
Yes, 34 or 35. Yes.
My lord would come to XVI
Yes. 35. Yes.
35. It being clarified that the unit was originally agreed to be purchased by Lakshmi Narayan Udyog,
Hmm.
who nominated the purchaser to complete the purchase of the said unit. In its place and stead, request and direction of the purchaser, the owner, and the developer do each of them grant, sell, transfer. Now, why I want to show this paragraph, because the person who was buying the property, my learned friend's client, and the counsel engaged by my learned friend,
Hmm.
was aware that this company was the original purchaser.
Hmm.
And a search, as we call it, caveat emptor, a search is required to be done in respect of this company also. whether the title could have passed through to Nivedita Chaudhary, who had purchased the property. My lord would come to page 123.
Yes, please.
This is the order which was passed by Justice Kapoor on 5th of December 22, directing the sale of the properties. Of the company in liquidation. Next page, my lord. February 23. By an order, 9th of had directed to take forthwith possession of the properties of the company in liquidation. Significantly, one of the assets belonging to the company in liquidation is a flat situated at flat number 20I, Tower 1, Diamond City South, Haridevpur, Kolkata, West Bengal. Pursuant to order, the official liquidator had visited the aforesaid flat on 14th May and had taken actual physical possession of the same. However, since the flat was situated in a building complex, the official liquidator had chosen not to engage any security guards. Thereafter, by order dated 5th December 22, the court had directed official liquidator to sell the assets of the company in liquidation, including the aforesaid flat. It appears from the report dated 1st February 2023 filed by the special officer that upon visiting the flat, the special officer found that the lock outside the flat has been removed and there was a lady identified herself as one to be Rajbala in actual physical possession of the flat. Thereafter, the official liquidator had lodged a complaint with the police authorities on 25th January 2023. I find that there is a direct interference with the possession of the official liquidator. Admittedly, the aforesaid flat is an asset of the company in liquidation. Thereafter, the official liquidator has been directed to take actual physical possession of the premises. I also find from the minutes of the official liquidator that the official liquidator, as far back as in 2015, had taken possession of the flat and put a padlock on the same. In view of the direct and unauthorized interference with the possession of the official liquidator, the concerned police authorities are directed to provide all assistance to the official liquidator in taking over actual physical possession of the flat and putting a fresh padlock. On thereafter, next, the flat was directed to be sold, sale confirmed by this honorable court. Conveyance have been executed by my learned official liquidator.
Yes.
And as far as I understand from the records of the registrar, that the conveyance was presented for registration on 10th of October 2023. This is this registrar of assurance থেকে যে কাগজ বেরোয় তো कॉपी है मेरे पास नहीं है अभी दिया present purchaser by the official liquidator.
Yes.
My lord would see at this application at page 28, it has been affirmed on 4th day of January 2024.
Yes.
And the filing date is somewhere in April 2024.
Right.
My learned friend had also raised the issue that he had got a search done. And on the basis of the report of the learned advocate, my learned friend's client purchased the flat.
Yes.
I would like my lord to go through the search report. My lord would come to page 165. My copy is little hazy, but then I will try to assist whatever is possible. I have caused necessary search in the done in the registry office in ARA 1, ARA 2, ARA 3, ARA 4 for the period 2015 to 2021 and the district registry office at DSR 2 Alipur South, 24 Parganas. For a period 2015 to 2021, I did not find any record thereof in respect of the settlement record KMC mutation and all relevant papers in respect of the aforesaid property. My lord, the deed of 2015 is also registered in DSR 2. My lord would see from page 30. The first endorsement on the top, just after
Yes. Yes. Yes.
DSR 2. If the deed was registered in DSR 2, then the endorsement has to be there in the DSR 2 report and the advocate's record. Without verifying the same, the report of DSR 2 is at page 164. No records found.
Right.
If the proper searches were made, my lord knows the Transfer of Property Acts very clearly says, caveat emptor, the purchaser would be deemed to have notice. If he had notice about these facts, he ought to have been diligent. He ought to have engaged a proper lawyer to do a proper due diligence for purchase of the property. There is a mistake in the order which was passed by Justice Sinha of 2150, which most probably has arisen because of page 8 of the 266. At the time when Justice Sinha was passing an order, most probably he just went through one page and did not go through the second page.
Yes. Regarding the valuation.
Regarding the amount of 21 lakhs which has been reflected
Only for the garage.
only for the terrace.
Terrace. Sorry.
These are my humble submissions, my lord.
Thank you.
Yeah.
Yes.
But as well as the registry search part, my lord, I'll address your lordship. But my lord, my lord, after going through my lord the papers, my lord, that was my lord produced, and my lord, one my lord nagging question that came to me, my lord, how my lord the company became the owner of the property. My lord, even if I do not dispute the fact that there was payment from the company to Rajat Merchandise, even if I do not disturb, I'm not admitting it, but even if I say so, my lord, how will my lord, the property will be conveyed from my lord the Rajat Merchandise to my lord the company in liquidation without there being a deed of conveyance, my lord, under the meaning of Transfer of Property Act, read with my lord the Registration Act. My lord, one thing is to my lord follow the money, and my lord lordship knows my lord following the money may not be following the title of the property, rightly or wrongly, my lord, whatever it may be, the property, my lord, was conveyed to another person. If the company was the person who had paid for it for the benefit of the ulterior benefit of that person, company has the right to sue that person, or my lord, the seller, or whosoever concerned at that transaction. My lord, even if, my lord, I'll say, my lord, so far, the company has a right, my lord, against that, my lord, Mrs. Nivedita Chaudhary. If Nivedita Chaudhary has been, assuming, has been the beneficiary of money paid by the company, then they can recover the money from Nivedita Chaudhary. But my lord, how the property will become theirs? My lord, there is no, then my lord, there has to be a declaration of title somewhere. Or my lord, there has to be a deed. Nothing is there. Court, my lord, was never invited, my lord, to, my lord, this is not a specific performance suit also. My lord, first of all, my lord, there was no, even, my lord, for specific performance, the Supreme Court has stated, my lord, that there needs to be a registered agreement for sale, which may be specifically force compelled to be performed. Registered agreement for sale is not there. Allotment letter, money paid, even if that is the case. How will the title be passed on? Title passing on is simpliciter, not equivalent to money being passed on. Well, tomorrow, my lord, promise my learned friend, senior friend, that my lord, I'll sell one flat to him. He pays me the money. I did not give him the flat. There is no registered deed. What is his remedy? He can sue me for recovery of money, or if there is an agreement for sale, which has been registered specifically, then he may file a suit for specific performance, compelling me to sell the property to him at that
But the deed by which your vendor Nivedita Chaudhary purchased, that clearly mentions the company. So wasn't it your duty to undertake proper search? I mean, because Nivedita has been mentioned in her title deed, through whom you claim that she was a nominee of the company. So you must have at least looked into your vendor's title deed.
My lord,
That's the minimum, the first degree search.
I will have definitely, my lord, I'll come to that.
So how can we overcome that?
My
The
lord, I will
attempted, as rightly pointed out by Mr. Santi.
My lord, I'll come to that. My lord, the difficulty is, if the title has not passed on to me or Nivedita Chaudhary, does not automatically mean it has passed on to the company.
But you have no locus to maintain this application then.
My lord, I will. My lord, I will address that also. Now, my lord, so far as my lord, my learned senior friend, my lord, had told to your lordship, my lord, page 65, my lord, their report of my lord, the learned advocate, 165, my lord, I stand corrected.
Yes.
That is, my lord, the first page, my lord, he had shown,
Yes.
which was a little hazy, 23rd of April 2021. My lord, kindly turns over to the next page. Well, this was not placed. My report is as follows. That Srimati Nivedita Chaudhary purchased the unit by deed number 3229 of 2015, registered at the office of the DSR 2 Alipur, South 24 Parganas. That after purchasing the aforesaid unit, she became the absolute owner of the unit. That is all that the flat number such and such.
But that's palpably wrong in the teeth of that report, of the deed, where she mentions the deed. But the deed itself contains a clause that Nivedita she purchased as the nominee of the company. So you cannot overcome that. I mean, the advocate also couldn't overcome that. That should have been reflected in the search report. And you as a vendor should have at least looked into that deed.
Lordship kindly recalls, my lord, those aspects of the my lord argument. where, my lord, I had shown to your lordship, my lord, the earlier deed was registered in DSR2. My lord, they did not update the e-Nathikaran system till 2022.
No, the difficulty is the deed is mentioned specifically in the search report.
My lord.
You obtained this search report,
My lord.
and you must have seen, any prudent person would have looked into that document, at least the deed,
Lordship kindly
which is mentioned here.
kindly sees, my lord, even lordship will kindly see page 100, that, my lord,
This is palpably contrary to the deed itself, that she became the free from all sort of encumbrances, etc.
kindly
If she was a
sees, my lord,
nominee.
page 35 once.
35.
Lordship, my lord, my learned senior friend had placed this particular
Right. 16, Roman 16.
sale agreement. Well, this has been placed by me also on number of.
Yes.
Sale agreement shall mean the allotment letter. So, my lord, again, this is an allotment letter, not a registered sale agreement. Kindly notes. But I'll come to that, but I'll show a few, my lord, decisions on that. Dated 1st of October 2011, issued and or deemed to have been issued by the developer to the purchaser, with booklet of terms and conditions annexed thereto, whereby and whereunder the purchaser agreed to purchase and acquire the said unit, and shall include all modification supplemental documents if made in writing in connection with the said unit. It being clarified that the said unit was originally agreed to be purchased by Lakshmi Narayan Udyog Limited, who nominated the purchaser to complete the purchase of the said unit in its stroke their place and state, and at the request and directions of the purchaser. The owner and the developer do, and each of them doth agreed to grant, sell, convey, transfer, release, assign, and assure their respective rights, title, and interest related to the said unit, without the above named original intending buyers being made party to these present. So,
You could have argued that that allotment letter is not sufficient. There's not an agreement conferring any right on the party.
I'm grateful.
But the difficulty is here in this case, that allotment letter has been given effect to by your vendor.
My lord.
And she mentions she is a signatory to this agreement, or at least it's her agreement. This she derives title through this. It's specifically mentioned there that that allotment letter is given effect to by virtue of execution of this deed. So that allotment letter is a past chapter. It's given effect to. So this is not a, they are not seeking a specific performance of anything. Your vendor herself relied on that allotment letter, and by virtue of that she purchased as a nominee of the company.
My lord.
And you claim through her.
My lord, I am
your rights cannot be better than her.
No, my rights cannot be better than what Nivedita
Chaudhary, right.
Now the question is,
this is an admitted position from the deed.
No, this is an admitted position, my lord. In fact, my lord,
so now we cannot look back at the allotment letter. What was its legal strength? Because that has been given effect to. Now the deed is there.
Effect to, and my lord, this is a registered agreement. This clause is a part of the recital. It is
but
not...
you are taking a risk, because if you say that allotment letter could not have been enforced, then this deed is also a bad deed.
My lord,
this was in pursuance of that only.
My lord, my argument would be,
yes.
My lord, once it is reduced to a deed of sale which has been registered, my lord, it overrides every allotment letter.
Precisely.
It overrides every allotment letter.
Yes.
So whatever there is in
and the deed mentions
the
deed mentions that she is a nominee of the company.
My lord, whatever is mentioned in the body of the deed, my lord, that is what I can look into. Secondly, my lord, this allotment letter not being a registered document, my learned friend argued that, my lord, caveat emptor, buyer beware. My lord, while I am purchasing a property,
no, buyer beware on the basis of the averments in the deed itself.
Grateful, my lord. But where will I verify these averments from? Where is that public record?
You are claiming through Nivedita. You cannot go behind this. You cannot verify this. If you verified and found that Nivedita had no title, you are claiming through Nivedita. So whatever Nivedita could do, you can. Nivedita is relying on that allotment letter. She is claiming herself to be a nominee.
My lord. True.
So how can you improve that?
My lord, I
don't get that.
My lord, I'll come to that. My lord, the fact remains, my lord, the money was paid back to the company also, which has been recorded. But then, my lord, I'll just, my lord, place this before coming to that other argument. My lord, the allotment letter is, my lord, has been mentioned in the deed of conveyance. My lord, my learned friend argued that I should have been more careful, and my lord should have looked into what this allotment letter is.
Please forget the allotment letter.
Or, my lord, the nomination.
Nomination.
Very well. My lord, I should have looked into the nomination. My lord, I put a question to myself.
No, you should not. Even on a plain reading of this document, you should have looked at this document only. And if you looked into this document, it is found that the purchase is being effected by Nivedita being a a nominee of the company. Nivedita accepts that she is a nominee of the
My
company.
lord, when I say that all nomination and allotments, my lord, because they are not registered document, first of all, I could not have through search found them. I
No, no,
could only look at
From
this
this
document.
deed, yes.
Yes, my lord, where is the difficulty in this deed that, my lord, will transpire that the nomination was bad? If that be the case, then, my lord, I would be nowhere. My lord, this nomination, my lord, it in fact aids me. My lord, it is not bad. And, my lord, the other documents for which, my lord, I don't have any, my lord, visibility to those documents from the registry. If
Alright.
there had been, my lord, that agreement for sale, allotment, assignment,
So you say
whichever
nominee or otherwise, Nivedita obtained title.
my lord, that one document is the, my lord, title passing document. This
Yes.
deed.
Yes.
All else, my lord, is not with the public records. So, my lord, even with greatest of my lord, my lord, humble understanding, my lord, I could not have seen those documents in the public record.
Hmm.
My lord, I would go where? Then, my lord, I will have to take inspection of the books of Lakshmi Narayan to understand how the money has been paid and all that. My lord, why? Because the title has passed. My lord, that is why, my lord, a document is registered. It gives, my lord, my lord, a legitimacy. And that legitimacy can only be disputed by another registered document, which is, my lord, in this case, not there with the company. My lord, everything, my lord, all, my lord, said and done. My lord, all the papers that they have, my lord, produced, they say, my lord, even, my lord, I just pause here for a moment. Kindly takes, my lord, page 9 and 10 both of, my lord, the CA 266 of 2017, which my learned friend has relied upon. Although it is, my lord, it doesn't change the, my lord, color of my case. Still, my lord, I'll show you to your lordship, my lord, paragraph 3 at page 9.
Hmm.
This is to confirm and to place on record that the transferee has reimbursed to me, stroke us, the said advance paid by me to you for purchase of the said terrace. My lord, this is issued by Lakshmi Narayan to Rajat Enterprises in 2015. Next page. Same language, paragraph 3, page 10. This is to confirm and to place on record that the said transferee has reimbursed to me, stroke us, the said advance paid by me, stroke us, to you for purchase. This is signed by both, my lord, the Rajat and my lord, the Lakshmi Narayan. My lord, then, my lord, kindly sees page paragraph 4 at page 10. In view of the aforesaid, you are requested to kindly accept the transferee as purchaser. So, my lord, in view of the reimbursement received, they say, my lord, I do not know the correctness or otherwise of this document, but
What
if
would
on
be
the
the-
face of it, they are relying on this document.
There's a larger question. What would be the position of law if a company petition is
But-
pending,
My lord,
even if there is no order?
my lord, I'll come to that. My lord, company petitions, my lord, kindly, my lord, for a moment, my lord, keeps aside the fact that this is a company in liquidation. Had it been an individual, my lord, because Transfer of Property Act does not treat a company separately.
No.
Neither does Registration Act.
No.
So, I put a question to myself, if my learned friend's client was not a company, but an individual, kindly, my lord, envisage that suspect. What would happen in that case? He would have been asked to sue the person for recovery of money.
Even if that be so, could the company at that point of time, through its directors or whoever authorized signatory, have transferred the property at all? Or had
My lord, the
entered into
question of
any
fraudulent
transaction?
preference would come up. Whether, my lord, because of the time of winding up, my lord, these kind of transactions, that would come up. My lord, I am really, my lord, not required to, my lord, go into that question. I tell your lordship why. Because even if there has been a foul play in action, the fact remains the registration of in the conveyance deed, there is nothing. They can obviously, my lord, if they have been beneficiary of some illegality, they should pay for that. But who should pay for that? The person who has enjoyed that benefit. And the question is that, rightly or wrongly, there was a deed of registration, the deed of sale registered, paid for, and it was in the registry. All the documents which are there to counter that registered deed are unregistered. And, my lord, to be very candid with your lordship, my lord, these are all the records of the company. These are not bank documents. This will not be, my lord, I do not know where the money has moved, because this is not Bankers Book Evidence Act.
No,
that
that's
it will
not
be
your
the
lookout.
presumption of correctness of those. Because, my lord, we do not know actually what has happened. These are again the company's documents.
What is your,
Malad,
I mean, what is your understanding of this? Because of the pendency of the company petition, shouldn't the principle of Section 52 TP Act, Transfer Property Act apply?
transferee pendentiality. Malad, if that be the case, because of lease pendants, Malad, if that be the case, Malad,
One, Section 52 principle. Second, company through its directors did not have the locus at that point of time.
it would, Malad, it would. Malad, join issue there. It
Yes,
would,
yes.
had it been,
Yes.
it was the company's property. If the company had made a conveyance, if the company had somehow alienated the property,
All right.
because my lord, the company never came into being of the property, so my lord, the next stage of alienating
Company was never the
arises.
owner of the property.
Never,
It was not an asset of the company.
my lord. I am grateful, my lord. Had it been in some way or the other, had been an asset of the company, then alienating question of alienation does not arise unless you actually have the property in the first place.
What it alienated at best was its right to purchase that property.
It alienated
by
perhaps
virtue of
its money.
That too by virtue of an allotment data which does not have any force of law.
My lord, perhaps it alienated its money. I am saying so. Perhaps it did. But my lord, for alienation of money, there are other remedies. You cannot, my lord, unsettle a registered deed by way of simply showing that I have paid money for it. Tomorrow I sell Victoria Memorial to him. My lord, without a registered deed, he can sue me for what it's worth. But how will he, my lord, enforce that?
Nowadays, Victoria Memorial is not a good example. After the marriage is being held, it's not so sacrosanct.
My lord.
Victoria Memorial, another building.
My lord. We'll let us, my lord, there are many examples now.
Don't give an example of the High Court, please.
Never. With due deference to this.
All of us will be,
my lord, no
literally on the footpath.
My lord. Literally.
Yes.
So, my lord.
So very well. Yeah, understand your point. Yes, very well.
My lord,
it was never an asset of the company. So
notes of argument.
Yes.
My lord, first notes of arguments, my lord, principally, my lord, there were three legs of our argument.
Why two notes of arguments?
My lord, lordship, my lord, because my lord, they
new points.
A new compilation of documents, lordship permitted us to, my lord, give a supplementary notes of argument.
Yes.
So the first notes of argument, my lord, touches upon, my lord, three aspects of the argument. First is, my lord, actus curiae and nemanim gravavit. My lord, for which, my lord, I had, my lord, cited judgments of Southeastern Coalfield, my lord, where it says that if, my lord, the honorable court passes an order,
yes,
by itself, my lord, there is no error on the part of the court. But because of a submission made from the bar or by a party, because the court was that error had crept into the order. So, my lord, that is also, my lord, governed under the principle of, my lord, I can place those judgments once more.
So he had placed.
Yes,
I recollect.
And, my lord, the second issue is, my lord, the court, my lord, passing that order, my lord, because, my lord, it has inherent jurisdiction to correct it.
Lord, even if it falls short of fraud, I mean, if there's a mistake of the court, error apparent on the face, then court can correct.
My lord, fraud, lordship, my lord, I have argued fraud also.
Fraud is the highest level. Review is the lowest level. So somewhere in between also there's a gray area which comes within actus curiae.
My lord, in terms of, my lord, yes, my lord. Because, my lord, that was the first target of argument. The court has inherent power that once it notices there is an error which has crept in, that, and, my lord, everything follows consequentially from that, would be set at the right course of action. Next, my lord, was, my lord, that this was the High Court. My lord, had it been the NCLT or, my lord, any company law board, I could not have taken this argument, because this is High Court, my lord. This is Article 215 under Constitution of India. My lord, this is a court of record. My lord, court of record merely does not mean that it is a record keeper. It does not only have the right to keep the record correct, it has a duty towards keeping the record correct once it becomes aware of it. That is, my lord, the second. And, my lord, fraud, my lord, Order 6, Rule 4, I am not going there. My lord, what I argued was, my lord, manifest fraud. My lord, when, my lord, a court is led to passing an order by virtue of certain arguments or, my lord, certain statements made by a party, which was not correct on facts, that would, my lord, be treated as fraud. My lord, for which I had cited three judgments. My lord, at 2022 live law also, my lord, on the last occasion I had cited. Those apart from what is there in the notes of argument.
That is not a part of them.
Not part of this notes. I will again supply a copy.
I'll forget and I'll rely on the notes.
I will, my lord, I will supply, my lord, two more judgments apart from what is there in the notes of argument. The other one I'll just cite to your lordship in a moment. My lord, and the fourth leg of argument, my lord, also, my lord.
But don't cite new judgments in reply.
I am not, my lord, only on the
They've already argued at length.
Suraj Lamp, I will only cite a judgment. Suraj Lamp has been followed in 2023, specifically saying
you could have cited that at the inception.
My lord, it is there. Suraj Lamp I have cited. That suffices.
That's sufficient. That
suffices.
Don't cite in other.
Very well. That suffices. So far as, my lord, the fourth leg of my argument, which developed over time after I got a clarity of what documents they are relying on. My lord, that was, my lord, that first argument that I made today, that no registered deed of conveyance in favor of the company. Company is not an individual, it's a juristic entity. There has to be a deed of conveyance somewhere or this other. How the company became owner of this property, company or its predecessor, but by reason of acquisition, merger, or the like. But nothing of that sort has been, my lord, relied upon by my learned friend. Because, my lord, I do not find today also, my lord, the records which are there. At most, my lord, I can understand the company may have made some payments for someone getting a benefit, but that does not ipso facto confer title upon the company. It would not upon any other entity in law in our country. So company is in no better footing than any other entities when it comes to passing of title is concerned. Now, my lord, I have cited Suraj Lamp, which is part of my notes of argument. Kindly, my lord, takes few paragraphs from there. Kindly, my lord, takes paragraphs. And, my lord, I have also in my notes of argument a few other things I have indicated, that the company did not take adequate steps to protect the occupation, protect their property. If it had been their property, they said that it is not required, but then nothing, that was because when I had taken the inspection, nothing was there. There was no notice, no padlock, nothing.
No, they say there was a lock. The Justice Kapoor's order records there's a lock which was broken open and the lady.
That order does not record, my lord, when it was broken open. My lord, the fact is, my lord, this is on instruction I'm saying. My lord, I have been staying there for almost a year. I have done the entire interior decorations. Lordship can envisage the situation. Kindly seize, my lord. Suraj Lamp, my lord, this is, my lord, marked as age.
Yes, I've got it.
Yes. Page below. Suraj Lamp.
The first judgment annexed to the second supplement, the supplementary written note.
My lord, paragraph. Yes. My lord, this is, my lord, the Ramkumar judgment I have also annexed in the supplementary notes, so I stand corrected. So it is all there.
So it's there.
All there.
Yes, I was
Suraj
seeing
Lamp,
live.
paragraph 16 to 19 and 24. Kindly takes at page. Next, scope of an agreement for sale.
Yes.
Starts with Section 54 of the Transfer of Property Act makes it clear that a contract of sale, that is, an agreement of sale, does not, of itself, create any interest in or charge on such property. This court in Narandas Karsondas essay versus essay Kamtam observed, a contract of sale does not of itself create any interest in or charge on the property. This is expressly declared in Section 54 of the Transfer of Property Act. The fiduciary character of the personal obligation created by a contract for sale is recognized in Section 3 of the specific.
No, you are proceeding on the premise that letter of atonement, if that could be considered to be a.
At all agreement for sale. Well, even that is not sufficient.
This proposition is too well settled.
It is too well settled.
Too well settled. At best, an actionable claim for specific.
19. Kindly see is 19.
Yes.
Just I'm skipping over 18 and 19. It is thus clear that a transfer of immovable property by way of sale can only be by a deed of conveyance, sale deed. In the absence of a deed of conveyance duly stamped and registered. By the way, my lord, stamp duty is also nowhere. And registered as required by law, no right, title, or interest or in an immovable property can be transferred. 19. Any contract of sale which is not registered, which is not a registered deed of conveyance, deed of sale, would fall short of the requirements of Section 54 and 55 of the TP Act and will not confer any title nor transfer any interest in an immovable property, except to the limited right granted under Section 53 capital A. According to the TP Act, an agreement for sale, whether with possession or without possession, is not a conveyance.
Section 54 itself says an agreement for sale.
Perhaps this is too well settled. Perhaps this is too well settled. I just for my own satisfaction.
Definitely, yes.
Well, at page 667 of the report, paragraph 24. We therefore reiterate.
Yes.
That immovable property can be legally and lawfully transferred stroke conveyed only by a registered deed of conveyance. transactions of the nature of GPA sales. This was that because of those days, power of attorneys were used. GPA sales and SA GPA will transfer, do not convey title and do not amount to transfer, nor they can be recognized or valid mode of transfer of immovable property. The courts will not treat such transactions as completed or concluded transfers or as conveyances, as they neither convey title nor create any interest in an immovable property. They cannot be recognized deeds of title except to the limited extent of Section 53 capital A
Yes.
of the TP Act. Such transactions cannot be relied upon, but this is well settled. But the other judgments are also there on this same point. I am not placing them. But again, I have to reply to him.
Yes,
then.
he has to reply. Could have argued before he started. Yes, if you want to add, then yes. Any other thing you want to deal with?
Lord,
Your written notes are before us, before me. Yes.
Lord, Lakshmi Narayan Udyog is referred to in the agreement. That is all there is. It is not a confirming party. There is no way connected to this agreement.
Notice that. Yes.
But those are my submissions, but I have placed everything in my notes of
Yes. Subject to what is being added.
Subject to if I have to address.
Yes. Please.
And my lord, I have shown your lordship that according to their own papers, my lord, which my learned friend relied on to show that 21 lakhs for terrace, 1.04 for the flat, coupled together 1.27. Well, that he showed. My lord, it's the same document. My lord, if he relies on that document to be correct, then my lord, does reimbursement is also taken to be correct. I'm grateful.
Yes.
I'm not going all to this, my lord. First, their application, the judge's summons. Their judge's summons is disclaimer. Well, what provision of law this application has been filed, I don't. 433, 434, 439, 434 unable to pay more than 500, then winding up. It is a disclaimer. Perhaps, my lord, the appropriate manner section has to be mentioned. But if you're asking for disclaimer, well, assuming now admitting.
What would be the appropriate section?
535.
535 is there, then a wrong caption settled.
No, disclaimer. Disclaimer.
Caption does not matter.
Perhaps, my lord, if would have been the order have been passed in there, suppose, then the property is not under the hand of official liquidator, that means sold out.
In everything, every subsequent sale, everything, if that order goes, rather the effect of that order goes, every subsequent, happening goes. All else is vitiated. Whatever happens
One order, my lord, they have relied upon, that has not been challenged. My lord, page 120, order passed by Judge Arindam Sinha. But here, second 121.
Yes.
He referred to his letter 19/20 issued by the company.
Yes, he has referred to that.
Yes,
that
yes.
is the pivot of this argument.
531 and 531 capital A. Here specifically mentioned after presentation of the winding up, anything malavoid. Anything.
Yes, that is one of the questions I asked him, that what would be
Anything
the
is
effect
fine.
of pendency of a
531 capital A specifically mentioned that order has not been challenged by anybody.
No, but this is subject to the proposition that the company has to have a title in the property in the first place. If the company, as you said, Victorian Memorial, for a property which is not an asset of the company, this entire proposition is not attracted at all.
Asset of the party admitted Nivedita Chaudhary.
Who admits?
Nivedita Chaudhary has been not been, he has tendered his resignation.
No, there's a distinction. Company was not the owner. Company was the intending purchaser, as per the deed of Nivedita. Company was an intending purchaser by virtue of an allotment letter, right? Now, company assigned that right to Nivedita.
Yes.
So now the sale was concluded, even if Nivedita was or was not an assignee of the company. There is only one valid registered, valid or not will come to later, one sale deed that has been executed in favor of Nivedita.
That has been set aside out of the court. Allow us.
No, we are coming there. But difficulty is, what is the right of the company in the first place in that property?
Nivedita Chaudhary.
You don't have any title. You didn't have, the company didn't have any title in the company.
Company decided to purchase. Company nominated.
Decision of the company to purchase is not sacrosanct. Its decision to purchase shows that it was not the owner.
If it is not the owner, 531 capital A say before presentation, after the presentation of
that comes in.
anything goal. 468. Fine, kindly first 468 first. I am not going to their dispute. I'm only in 468, kindly 468. Not going to this dispute. Not 468. Deliver a property to liquidator. The court may at any time after making a winding about got it.
Yes, got.
Well, the court may at any time after making a winding about require any contributor for the time being of the list of contribution any trustee, receiver, banker, agent, official or employee or the company to pay, deliver, surrender or transfer forthwith or within such time as the court may direct to the liquidator any money, property, books, paper, anything. It's the duty.
To which the company is prima facie entitled. So what is this? A money, property, book or paper? Which
Property or
how is the company prima facie entitled to this property?
yes, properties belong to company. Company decided
How
to
can it
purchase.
belong to the company if the company decides to purchase it?
Yes, through
I
the
purchase something, I intend to purchase something means I am not the owner.
purchase.
Owner does not purchase his own property.
My lord, company assigned the Nivedita Chaudhary.
Assign what? It's right to purchase.
But Nivedita tendered his resignations. And my lord, when the property came to the knowledge of the official liquidator, official went there. Nobody was there. He put a complaint to the police officer and he has been surrendered and arrested.
Whatever acts have been taken, the company show us something to establish that the company was ever an owner of the property or that the company even was prima facie entitled to the property. Entitled means entitled, it's an adjective cropping up from title. So where was the title of the company in the first place to call it an asset of the company? It was neither money nor property nor books or papers of the company.
Nobinita Chaudhary is the nominee. And his nomination has been withdrawn, he has been resigned. He is nobody. Then
there is one purchase deed.
Yes.
Sale has been effected, a valid registered sale deed in favor of Nivedita Chaudhary, right? The company, this was never an asset of the company. Even if she purchased as a nominee of the company, as per the Transfer Property Act, title passes to the purchaser, not to the nominator. Not to the nominator.
Nominee by the company. My lord, his nomination has been withdrawn, he has been resigned. Money, if any, given by the company.
The company's rights lie, if you did not receive the money, to have a money claim against Nivedita.
No, we have taken the property. The Nominita Chaudhary has been arrested. He did not raise anything. 531
arrested for what? We don't know.
Oh, yeah, he has taken the property. Then we made a complaint and wrote a letter to the handover the same. They did not. We make a complaint to the police officer and he has been arrested and signed under bail.
Arrest does not mean anything. Criminal court's orders are not binding on the civil court at all. Not the company.
Number two,
he was arrested or not wrong. Might have been wrongly arrested.
But he is in nominee. He has been tendered his registration.
Her arrest does not mean anything. You prove us that the property ever under, since you are relying on 468, show us something that the company was ever prima facie entitled to the property.
Now, 531 capital, the order has been passed that this property belongs to company. Honorable could direct the official.
Wasn't there a fundamental misconception in that?
If it is a wrong,
it was never an asset of the company.
No, if it is a wrong order, my lord, till date that has been challenged, and the sale has been made not by private treaty in publication before the court of law. Had the opportunity could have come before the court and stated this sale has been wrong. It is property of the Nivedita Chaudhary. It is not the property of the company in liquidation. Company is not entitled to sell.
Some error going to the root at the inception cannot be subsequently rectified. Whatever sale took place subsequently was subject to the initial title of the company.
But publication has been made at the opportunity. Thereafter, they have come. That order was earlier and sale was made open court in under the supervision of the court.
You cannot apply the principle of factum valet to an illegality.
Their duty to hand over 531 capital A.
Provided in the first place, it's an asset of the company.
Asset of the company because
it was never. How did the company admits that it had an allotment letter for purchasing a property. So companies rights stop there. They were only an intending purchaser, which right they nominated, and by virtue of that nomination or otherwise, Nivedita is the person who has become the owner of the property. Valid registered sale deed executed in favor of Nivedita, nominee or not nominee.
A real letter for direction we have filed.
Company had best had an actionable claim.
my lord, page 7, my lord, paragraph 7.
Company was never the owner of the, it was not prima facie entitled to the property.
Yes,
It was at best entitled to have a specific performance of that allotment later if it was an agreement.
226, paragraph 7, during the possession of the flat, the company lying Diamond Harbour City along with the 2 parking place, the official came to know
Company court proceeded on the premise that company has a right.
that transaction with the said by making correspondence also paying for purchase consideration from the company's fund. On the company's fund, payment has been made. It has been revealed from the aforementioned information and document that though the entire transaction was made by the company, but the flat had not been conveyed to one Uday Chaudhary, proprietor of Srimati Ajay Chaudhary, ex-director of the company, by the aforesaid by executing the document. Upon requesting nomination being that your pair kindly see, or pair, the Honorable Court may direct declare that the conveyance as enumerated in paragraph 7 as void according to the provision 531 on local justice.
What is the position of law? Suppose some company nominates a person, that person purchases the property. There's a valid execution of sale deed. So as of that date, the purchaser is the owner of the property in the eye of law. Nomination or non-nomination. Purchaser is the owner. There cannot be any doubt on that. Now, suppose even if the company paid an amount, reimbursed the whatever, the consideration amount to that Nivedita, then also automatically the company does not become an title holder.
Made declared that the conveyance.
You are reading from
as
where?
Enumerate.
You are reading from?
Order passed by Sinaz as page 121. That has been
121, yes.
Specifically mentioned. As such, there will be ordered in terms of pair A and B, which are reported below. The Honorable Court may declare the conveyance as enumerated in the paragraph 7 supra as void according to the provision of 531 of the Companies Act. The leave be given granted the official to sell the flat in question as is what is their basis for the purchase of purpose of it. That has not been challenged till date. Only
In their application, how do they claim knowledge of this order or these proceedings for the first time?
because publication has been made.
The last publication.
Sell.
No.
After
But after I was ousted from my house.
So they could not have any opportunity of knowing.
After that, we taken positions. Nivedita Chaudhary is in the flat. They did not release. Then we reported in the police.
Mr. Datta, this morning, how many advertisements did you look into in all the newspapers as regards these sort of?
But it was their knowledge. But when they placed this application, before that is gone into liquidations. And date of presentation I have placed. Date of presentation is 28 June 2013. 531 capital A.
But this will be a legal autocracy then. If we usurp everything in the name of the company court's powers, this will be legal autocracy, judicial autocracy, more worse than that.
Sale was made publication. Several intending purchases were there. Subsequently, it was placed before the court. In open court, it has been confirmed.
How could they know?
But
By the newspaper publications?
Yes. Application made.
My learned friend had clearly stated that he has been outside. And after being outside in terms of the orders passed by Justice Kapoor,
Yes.
he ought to have made inquiries. And before the second sale came, the sale was confirmed by this learned court. Justice Kapoor on the June 30.
When was he ousted?
26 June 2013.
He was outside sometimes in February 2023.
Specifically mentioned. Officially
February 23.
February 23.
23, man.
February 23. And Justice Kapoor's second order?
26 June 2013.
26 June 2030.
2033.
23.
23.
Page 127.
So it is after 4 months. During having my learned friend's client having been outside,
Then should have been.
she ought to have made due diligence within 4 months. I before Justice Kapoor second order wherein he
Had the
confirms the sale.
Suppose he did not. Was title ever conferred?
My lord,
Law did not confer any title.
as far as on the issue of title, whether the company had a chosen action, whether those issues,
Chosen action at base. That's the exactly right term.
that's something where I have not tried
You
to.
cannot do anything about that.
I'm not going to go into that area. Whether the company had chosen action, but there is some
But the
fraud.
court does not have that luxury to not go into that area.
My lord, I understand.
If I had, I would be the happiest person.
I understand, my lord. And
So I could have shut my eyes and says I am a company code and I am the chartered high court and I have just below the king. But we are not there.
I understand, and I understand there's been fraud which has been played against the creditors of the company, against my learned friend. But unfortunately, my lord, whatever we do, we are going to allow the
We'll have to
fraudster.
unsettle many things.
We allow the fraudster to get away. That's something which, as a person, how do I do that? That's something which bothers me out, and I had no answer to this when I was going through the papers. I had no answer to this, that we will allow. My learned friend has client
Bona
has
fide. Apparently bona fide.
bona fide, but then there is a issue where
You are right, but even if he looked into that document, what would he find out? What we
But-
are finding out now?
the only thing which would have found out that the company was in liquidation when the liquidation order was passed within the meaning of 531
That's-
531A,
One
whether
year.
there was a
One-
fraudulent preference during that period.
One-
But
That's
let us
some-
come to 531A once. Let us explore that chapter also. Because there also it has to pertain to the company. The asset has to pertain to the company, not any and every asset under the sun.
531, fraudulent payments, any transfer of
Has to be.
531,
Yes.
any transfer of property,
movable or immovable,
movable
or
or immovable. That's the first question is movable.
movable.
Maybe
Yes.
as far as immovable is concerned, there might be an issue involved.
Yes. So now execution or other act relating to property made, taken or done by or against a company.
Within 6 months.
So how can you say this is something done against the company if the company had no interest in the first place?
The company had
After
Yes.
passage of title in their Nivedita's favor,
my
company-
lord, on that day when the title passed over, before that day,
before that, yes.
there was a chosen action which was in favor of the company.
Hmm.
The company had an actionable claim against the developer.
All right.
Means 10th March 2020, 15. Before that,
Otherwise, the developer would have very clearly would have gone and said that I am executing. He need not have come in with all these paperwork which were annexed to 220.
And those letters show that the company paid that amount to the Nivedita.
to Rajat,
Rajat,
the developer.
Rajat.
Whether the company Nivedita paid or not,
That is immaterial.
is immaterial.
company paid to the Rajat.
Company had paid the money. There was a chosen action on that day was with the company in liquidation.
Rajat is the promoter, company paid to Rajat.
My lord, it's a very tricky question, but the movable property or an actionable claim, as far as the company in liquidation, had not vanished on the day when the winding up application was presented before the court. Anything which is done
Before
This language is quite wide against the company.
against the company.
Yes, 531 is your best case.
capital is 1 year. 531 is 6 months, capital
Is 6 months and 1 year.
1 year. And
But
date of
then it's-
presentation.
Date of presentation of
That
the
has been
winding up.
531 capital specifically mentioned. Presentation.
It's not the winding up order. It's
No.
the presentation of the
Date of presentation.
petition. Date of presentation here, my lord.
Admittedly
It is
before.
covered.
28 June 2013.
My lord, few words, my lord.
No, so that's all, Mr. Dutt.
My lord,
You want to add anything?
my learned friends, my lord, are relying on page 9 and 10 of my lord CA 266. But just I pointed out, my lord, to show my lord the amounts that was claimed to have been paid by the company. The same document says they have got the money back. My lord, even that be the case, my lord, if they cannot pick and choose a part of the document to rely on. If they say that This is my document. I am relying on this 21 lakhs for the terrace, 21.04 for the flat. The same breath, the same document says you have got back the money. So, my lord, it even puts another nail on the coffin of the claim of the company that they have not, because they.
What is your interpretation of 531
My lord, I will come to
against
that.
the company?
I'll just come.
Because that is,
My lord,
I find,
531 fraudulent preference.
yes.
My lord, the line 3. Any transfer, I'll place any transfer of property, movable or immovable, delivery of goods, payment, execution, or other act relating to property made. Now, I pause here for a moment. Taken or done by or against a company. Transfer of property, immovable, done by or against the company. Where is it?
Company had an interest.
Company had an interest over the money, not on the property.
No, to purchase the property by that letter of attornment or whatever.
That was in 2011, by the way, my lord. That is not that 6 months window. It was far before that.
No, the transfer, the rate of the transfer is irrelevant.
Rate of transfer.
No, not that.
Rate of transfer is
That
there.
was subsisting. The
But
rate
the
of
only
transfer
issue
is irrelevant.
Only
That
issue
my
is,
lord would
my lord,
also-
even if this is a fraudulent preference,
I had also placed the order passed on 1st of August by
Yes.
Justice Patharia. Undertaken by the company.
Undertaken.
Whereas the company had undertaken not to transfer or alienate any of its properties.
Yes.
so they have, my lord, in no manner alienated any property. If they have alienated any sums of money, that they are free to pursue.
It's an alienation against the company, against the interest of the company.
Against the interest of the company. If the interest is affected, I put a question to myself, how do you protect your interest?
531.
531. But can it, my lord, can it, when the deed,
531
my
was
lord,
relied on by
interest of the
justice.
property,
531 was relied on by
my
the
lord,
court.
intention, in respect of immovable property, they have intention. In respect of money, they have done it. So in respect of money, they are entitled. In respect of immovable property, it stated, it ended with intention. So, my lord, they cannot enforce that part of, my lord, under the 531. My lord, if I am, my lord, in other words, my lord, nothing translated into action insofar as, my lord, conveyance of the property is concerned. If something translated insofar as, my lord, paying of money is concerned, then definitely they will be covered, because this is solely, this 531 is covering movable, immovable.
Boils down to whether chosen action or actionable claim comes within the purview of section 531 against the company. That's the rudimentary
Actionable
question.
claim.
Ultimately, we have to come there.
My lord, my lord.
Whichever way we go.
My lord, my lord. So actionable claim and, my lord, the title of the property, my lord, are on two different pedestals. My lord, so far as, my lord, the money, if they have paid it, they can claim, they have to prove it also, my lord. Otherwise, they say in their own letter that we have got it back. Now they say, no, we have not got it back. So, my lord, they'll have to, even if suppose, my lord, they go for a money suit recovery, they have to justify this document. They say that they have, even if this document, then there has to be a declaration of this document to be fraudulent. Or even if they go by that 531, then it will only cover, my lord, so far as the money is concerned. That the deed of conveyance, which from Rajat Enterprise, the title passed on to Nivedita, company, my lord, the limited scope of the company was, I was going to purchase it. I probably had paid some money for it, but I didn't take it. Let Nivedita take it. But the memo of consideration in the deed shows, my lord, the money has been paid from Nivedita to, my lord, the Rajat Enterprise, the erstwhile seller. The deed itself does not record any money being paid from the company's coffers to Rajat Enterprise, the erstwhile seller. So these are, my lord, registered documents. So, my lord, this can be countered by another registered document, which is, my lord, in this case not present.
Thank you.
I'm grateful to you.
Yes, please file. Are you filing anything?
I had filed my.
You had filed together.
My lord.
এই একটুখানি ইয়েগুলো রিটেন নোটস গুলো আমার একটু গুছিয়ে দাও। এটা আজকে পিটিশন, হ্যাঁ পিটিশন ক্রিয়েটারটা রয়েছে। Hearing is concluded. Push up. The matter is reserved for judgment. The matter as CA 27 of 2024 is reserved for judgment. Great. Thank you very much. Which? এটা একটু পাঠিয়ে দেবেন এই পাঁচটাই এটা আলাদা থাকবে অন্য কারো
And for the respondent, Mr. Davis has joined virtually.
Mr. Dev has joined virtual, right?
Now for the review applicant, my lord, I'll be seeking an indulgence from my lord.
What indulgence?
That Mr. Gupta is on legs before the Honorable the Chief Justice.
No, Mr. Dev was arguing.
No, Mr. Dev has concluded.
Oh,
My
yes.
lord had put one question to us, whether 141 of the Civil Procedural Code will
Oh, that.
have any bearing on us. We have answers to that ground, my lord.
Yes, so
Seeking one-
next Friday, what can be done?
I'm sorry, my lord. Could I come back at 2 and adjust for 10 minutes, my lord? Matter going on before the Honorable Chief Justice, a tender matter. Kindly, my lord. Permits to come back at 2 by the clock. 10
Two, I have appellate said matters.
For the 10 minutes, I shall come. I don't want to.
When? Now it's 12:34.
At 2, my lord. If it's.
No. Appellate said matters are fixed at 2. So next Friday then. On the prayer of the petitioner, the matter is adjourned for the day. Please give your names. Yes, Mr. Dev's name. Please. And yours. Local.
Kindly adjourn item 8. Kindly take up item 9.
Till next Friday.
For a fortnight.
Fortnight.
This is the review application, my lord. I will press it, but not today. Because my lord, something very serious has happened on the last occasion. My attorney was perhaps not fully informed, and an impression was given to your lordship, basis what was submitted by the Delhi Council, that we are trying to delay the matter. What was
I've forgotten, but
yes. Last Friday, this matter.
Yes.
Yes, for a week or two,
Yes.
on two occasions, time was sought.
No, Mr. Thakkar, this has to end at some point.
Yes, my lord, it has to.
I'll request all of you to file a written notes of argument and conclude it.
My lord, there are some issues which.
No, I now recollect. I said that particularly in respect of foreign awards, Mr. Thakkar, we have to be more stringent.
yes.
I mean, we have to be shorter.
Yes, my lord, will be very short, my lord. That's why I'm not.
Because of all of us. I mean,
No,
we
but
give
why
the
I
wrong
tell you,
impression.
lordship, why we were not ready to argue on the last occasion. We would have been ready to make our submissions. Was not told to your lordship that there has been what they call a global pen down. A global pen down in this matter agreed by both parties, because the larger battle has been fought in the US, and the US attorneys had agreed to a global pen down. So we were told that they will also not press for hearing. This was not told to your lordship. I have it on an email, but I don't want to show the email because it will result in that lifting of what's it called, a privilege.
Privileged communication.
Yes, privileged communication. So, my lord, I'll not press the review now. Kindly take up the main matter, please, my lord. Since I cannot be now accused because they procured my breach.
You're not pressing the review?
No, I will press, but kindly adjourn it for the time being. The review may be adjourned for a fortnight. If it commences to your lordship, or even 3 weeks, as your lordship deems fit, we'll press the review.
Why?
Why, my lord? Because I don't want to be seen running away from the award.
Why for 2 or 3 weeks?
Because, my lord, there are 2 more respondents. Mr. Bachawat is there and Mr. Mitro is there.
But they're not here today.
But I'm there for Caesar's wife, respondent number 4.
Mr. Sajji is possibly the incumbent answering answer to my lord.
Yes.
Explain, lord, if my lord will kindly grant a minute's time. He's
Won't matter, he matter.
Onujit does on it.
But I'm pressing my case. He can join.
Very good.
Mine is the objection to I'm not pressing my review. Kindly take 9. Review may be adjourned on my request.
Section 9, you had to make your arguments. They were making that.
48, the section 48.
Section 48.
Mr. Bachawat Mr. Bachawat is leading me for respondent number 3, but he is not present today.
Absolutely, yes.
I appear independently for respondent number 3. 2 is the husband, 3 is the wife.
Section 48.
9, item 9.
9. 8 and 9
pleasure to record an order in 8 then. Your Lordship's pleasure would be to record an order in 8 because it's a separate review from an AP. A review from the EC.
On your prayer,
yes,
on the prayer of the review applicant, 8 order record. 8, item 8. So on the prayer of the review applicant, the review application is adjourned till March 7, 2025. এবার 9টা yes
Item 9, EC.
Mr. Thakur, Mr. Bachawat, you are the last set of counsel who will be arguing on section 48 in support of section 48, or there is some other set.
Mr. Obrojit Mitra is there, and Mr. Dhruvo Ghosh for 2 other respondents, 4 and 6.
Please argue in a nutshell and I'll take written notes because it will never end then.
No, Madam,
Because I have only one day.
I know, Madam.
And I cannot
I'll
help
be
that.
precise. I'll try to be as precise.
I know you will be precise, but
Because, Madam, in any event,
yes,
Madam, this is a problematic award. And I say problematic because I know after we've completed our submission, the Lordship will go through the award. Lordship will find problematic used at least 100 times. So it's a problem. According to me, now this is a problematic award.
Okay.
Now today, Malad, I'll urge 3 grounds, which perhaps go to the root of the matter.
So your application is? Just give me the numbers here.
GA2, please, Malad.
নোট এটা নেই না?
হ্যাঁ, note it.
কোথায় ছিল? ও বাবা। না, এটা খুলে লাভ নেই, আমি আরেকটা অ্যাড করবো, এটা তো হয়ে গেছে। ওটা থাক।
Please. কোনো দরকার নেই। Convenience compilation. 3টে ভলিউম আছে convenience compilation.
ওইগুলো দিন।
That's the award.
Yes, Mr. I'm sorry, Mr. Thakur, you spell your surname with 1K or 2K?
1K, please.
1K.
THAKER, please, madam.
K-E-R?
Yes, please.
Right.
Now, madam, my first contention
Yes.
is that the tribunal has granted reliefs which were not prayed for. And therefore, the award is perverse. The second contention is the reliefs as granted by the tribunal is contrary to Indian law. It is against the policy of India and 48(2)(b, fundamental policy of Indian law. Third is the reliefs granted by the tribunal are in excess of the reliefs permissible under the contract. In any event, so these, if I succeed in any of these 3, the award has to fail. May I place the first case? The reliefs granted are in excess of.
Your third point was reliefs in excess of
the contractual stipulation.
Right. Please.
Now, your lordship must have been told, otherwise, just for my sake, this contract is governed by Indian law. Specifically stipulates. This is a contract governed by Indian law. The tribunal has copiously referred to provisions of the Contract Act, the Specific Relief Act, and judgments made by Indian courts, because they are also conscious of the fact. Now, my lord, kindly have the reliefs which were prayed for in the first the statement of claim, which your lordship will find is also set out in the award. May I show your lordship from the award, and then I'll hand over the statement of claim.
Awarded copy.
Kindly have compilation 2. Convenience compilation volume 2 part B, where the reliefs are set out. Kindly come to page 481, please, my lord.
Yes, please.
481, paragraph 207.
Yes.
In its statement of claim dated 22nd June 2023, the claimant sought the following reliefs: declaring that UpHealth is the supermajority shareholder in Global Healthcare, declaring that claimant has good and marketable title over these shares. So, these were the declaratory reliefs. Then 463.3 is the reliefs of permanent mandatory injunction. These are, my lord, in the nature of specific performance. Specific performance. Then kindly come to 463.4, which is of some significance. ordering respondents, Azim, Richa Sana Azim, so Azim is R2, Richa Sana Azim is R3, Chaudhary, Damodaran and Kimberlite, the other respondents, to jointly and severally pay damages to Uphealth Holdings in the amount of 122.8 million as the most accurate, although conservative, measure of the negative financial impact on Uphealth Holdings of the respondents' breaches, misrepresentation and fraud. So,
you are for R2, R3, these people.
yes, the two Azims, husband and wife. Dr. Sabhat Azim and Richa Sana Azim, the wife, the two directors, promoters. I'm sorry, Dr. Azim is the sole promoter under the agreement. This also has some significance. Apropos the third limb, Azim is the sole promoter. The wife, Richa Sana Azim, is not the promoter. Doctor is the sole promoter. Anyway, that is the third limb.
Yes.
So, your Lordship sees declaration, specific relief, and damages. This, I read as damages in addition to specific performance. Damages in addition to specific performance. Now, kindly turn to paragraph 208. The other reliefs are cost, etc. Cost, interest, I'm not troubling your Lordship with. Kindly see 208 at page 483. Subsequently, on 5th August 2023, the claimant amended the relief sought as follows. This is very important. My Lord will kindly note, claimant amended the relief sought as follows. Did not make any amendment in pleadings. And I'll show your Lordship the amendment application also. So only reliefs were amended, pleadings were not amended. Now kindly see, the amendment which your Lordship will find is in 463.4.
No, are these in excess of the original reliefs claimed?
Beg your pardon, Malad?
Are these reliefs in somehow excess?
Your Lordship will see the reliefs.
If it's in excess, then they cannot. If they waive a part of that,
it is within.
If it's within, then they can relinquish a part of the claim. So
no, Malad, they don't relinquish the claim. Kindly see the reliefs. Your Lordship will 463.4 and 463.5. Your Lordship had seen 463.4 was a rolled up relief for damages in respect of breaches, misrepresentation and fraud in the aggregate sum of 122.8 million. Rolled up relief, 122.8 million for 3 acts. Fraud, misrepresentation and breaches. Now kindly see, they have only split it. I have no difficulty with this. Ordering the respondents in the amount of 1.7 million. Now kindly see this also. Please, my Lord, make a note of this because we are in the Indian jurisprudence, my Lord. Or such other amount as the tribunal may deem to be appropriate, arising from these respondents' breach of contract. So this is a contractual breach. And the tribunal applies section 73. Says that damages in addition to specific performance, section 73 principles applicable. No dispute. One issue is, or such other amount as the tribunal may determine to be appropriate. Can the tribunal, I ask myself, under this extend 1.7 million? This is an inquiry into damages. Is 1.7 million specified by the claimant according to Indian law, the highest which the claimant can get, or in the guise of, or such other amount as the tribunal may determine, can the tribunal exceed 1.7 million? But this is a sublimb of 1. This is still not 1. This is a sublimb of 1. An inquiry into damages, in other words, if I may frame it in a civil procedure language, an inquiry into damages, can it exceed the estimate given by the plaintiff? That is sublimb of 1. Then, my Lord, kindly see 463.5. Ordering respondents to jointly and severally pay damages to Uphealth Holding in the amount of 121.1 million or such other amount as the tribunal may determine to be appropriate, arising from the respondents' misrepresentations. So, my Lord, fraud is gone. Head of fraud is omitted. Now it is contractual breach to a maximum, I would say 1.7, and misrepresentations to 121.1. Now, I said, my Lord, no change in pleadings. Your Lordship will kindly have the statement of claim. Kindly keep this on record. This is the statement of claim which was filed. And I'll have to take your Lordship through some pleadings to show what was the pleaded case, what the tribunal has awarded. And the amendment, please also, my Lord, kindly consider the amendments. Yeah, both. What was the email? There are 2 attachments. Yes, 3 attachments. This should have been put together. Why haven't you put it together? Stapler, actually. Kindly give me a minute.
What are those? Those are amendments actually carried out, or
Yes, amendments carried out only to the pleadings, because your lordship has seen the awards refers that only the reliefs were amended.
yes, reliefs are not amended by virtue of this amendment application. This amendment application does not carry the reliefs, any amendment to the reliefs.
It has, madam. It has a schedule which has to be amended. Kindly see the
But
amendment.
you said that the reliefs were there were no amendment.
Were amended.
Oh, reliefs were amended.
Yes, yes. Reliefs were amended.
You say the corresponding pleadings were not amended.
No amendment in pleadings. The award also records that only the reliefs were amended. Your lordship has seen. Subsequently, on so and so, the claimant amended the relief sought as follows.
Right.
Otherwise, it would have said amended the pleading. And I'm just to satisfy your lordship, there was no corresponding amendment in pleadings.
All right.
Only the reliefs amended.
Yes.
Now, my lord, kindly have the statement of claim once, please. Kindly come to page 170. The number is at the bottom of the page, my lord. Legal arguments. Heading 4.
Yes.
Roman 4.
Right.
Legal arguments, claimants' claims. Claimant set forth the legal basis of its claim for relief. Respondents breached the original share purchase agreement as amended. Elements of breach under contract. Elements of breach of contract under Indian law. I'm not troubling your lordship with the pleadings which are there. Kindly come to 342 now. Remedies for breach of contract under Indian law. Under Indian law, specific performance and damages are complementary reliefs for breach of contract. Section 15A provides that any party to a contract may obtain specific performance of that contract. Section 21(1) of the Specific Relief Act permits claimants to claim compensation for breach of contract. Kindly note this, in addition to specific, no difficulty. In those cases, Section 21(3) directs the court to award compensation in addition to specific performance if the court decides that specific performance ought to be granted, but that it is not sufficient to justify the to satisfy the justice of the case, and that some compensation for breach of contract should also be made to the plaintiff. The cumulative nature of these remedies was explained by the Andhra Pradesh High Court in this. For your lordship's satisfaction, I have a copy of that. Not relevant, but it's what it is. The section is what it is. It's just because they've referred to it, they've taken, American attorneys have taken the pain to go through Indian law. So, damages in addition to specific performance. Damages in addition to is the only pleaded case, is the only relief.
So that's why you said that you take it that is in addition to that compensation paid by them.
Yes.
The damages.
Because the relief sounds in that. It's not in lieu of.
No.
It is not in lieu of.
In the alternative or.
It is not in the alternative. It is not in lieu of. Alternatively, may I just digress for a minute? My understanding of Section 21 is, or the relief of specific performance is, that specific performance will be granted if it is permissible under the Act. Once it is granted, it is also for the plaintiff to claim damages in addition to specific performance. The court may grant damages in addition to specific performance on such a claim being there. Court doesn't grant damages if there is no claim for damages in addition to specific performance. B, the court might hold that plaintiff is entitled to specific performance, but I will not grant specific performance, but I will grant damages.
That will be in lieu of damages.
In lieu of damages. Great.
In lieu of specific.
In lieu of, that is what the court awards.
Yes, absolutely.
Yes.
This is some other. I mean, this is in addition.
This is in addition.
It's a different concept.
Yes. And the third concept is, my lord, that in a suit for specific performance, the plaintiff prays for specific performance, and it holds in the alternative prayer that if the court, only if the court is not inclined to give specific performance, then kindly grant me so much in damages. These are the only three alternatives. There's no fourth, in my respectful submission, 21(1), 1, 2, 3. Now, my lord, here, his case is only on 21(1), addition to.
Yes.
And this is what his relief is. Then, my lord, he says 73, how the contract is to be calculated. Then he sums it up in 345. Together, the specific performance remedy available in the Specific Relief Act and the compensatory damages available in the Contract Act provide a means of putting the injured party in the position would have occupied had the breach of contract not occurred. So he makes it very clear. He's asking specific relief plus damages in addition to. Then, my lord, I'm not troubling your lordship with the performance of his obligations. He says that he has discharged all his obligations. Then, my lord, kindly come to page 175. starts the recital of the defendant's breach of contract, because your lordships has seen it has been split into first 3 heads, then 2 heads. Breach of contract, breach of my lord, fraud of I'm sorry,
Only
tort of misrepresentation, breach of contract and misrepresentation. So my lord, 349 onwards is his claim on breach of contract. Then my lord, kindly come to 199. I'm sorry, my lord. 190, please. Before that is his pleading on fraud.
Yes.
Fraud
You
is a
say
head
as per the revised reliefs, the fraud element is no
has
longer.
been given up, but the pleadings were not amended.
No.
So he's not claiming any damages arising out of fraud. His damages for breach of contract, misrepresentation. Then, my lord, kindly come to remedies for fraud and misrepresentation. I'm sorry, I'm so sorry, my lord. 193. 193 is now misrepresentation. Paragraph 379 at 193. So the 3 heads of his original claim: breach of contract, fraud, misrepresentation. These are his pleadings. Then, my lord, kindly turns to 199. Remedies for fraud and misrepresentation. So here, my lord, what I'm endeavoring to show you
is 4 a clubbing of the previous ones, or it's a
is a clubbing of 4. Yes.
the previous
Yes. C and D were, my lord.
individual components.
Yes. B was breach of contract. C was fraud. D was misrepresentation. Now C and D together is the relief claim under the heads of fraud and misrepresentation. And my lord, now by the amendment, what I'm trying to say is, your lordship understands. So fraud and misrepresentation together amounted to 122.1. Now misrepresentation alone becomes 122.1.
The quantification in the
It's the same.
pleadings tallies with the relief.
Yes.
Separate.
All that he does is he breaks it up. 1.7 for contractual, and there is good reason for that. When I take your lordship to the third argument, that there's a liquidated damages ceiling. So that is why he splits it into 1.7. So he thinks that my liquidated damages for breach of contract will anyway be hit by the liquidated damages clause. So let me now claim a larger amount on account of what the tribunal has done. He has given him nothing on representation, misrepresentation. Fraud was given up, 0 on misrepresentation, but the entire amount is for breach of contract. That is the third limit. Your lordship will be shocked. That is why I say it's a problematic award. Then kindly come to 394 is the reliefs. So remedies for fraud and misrepresentation, your lordship has seen 392. Avitel of the Supreme Court cited that I must get compensatory relief. Then 394 is his pleading on specific performance. Then kindly come to 395. Kindly see what his pleading on additional damages is. This specific performance, however, is not enough to put claimant in the position it would have occupied but for the respondents. Kindly see, my lord, fraud and misrepresentation. This is because respondents' fraud and misrepresentation were relied upon by the claimant when it entered into the original share purchase, and during the period before the original share purchase, as close and afterwards, when respondents perpetuated those misrepresentations and fraud, and when those misrepresentations and fraud became known, this had, my lord, kindly see, this had a significant negative financial impact on upheld holdings, which would not at this point in time be repaired merely by obtaining 100% ownership over and control of local healthcare. So specific performance is not enough. I have already suffered loss and damages, but by reason of fraud and misrepresentation. Kindly see, not by breach of contract. The pleading there, the summary of the relief is claimed on account of fraud and misrepresentation. When he amended the pleading, when he amended the relief, there is no independent quantification of 1.7. Then, my lord, may I read further? Pursuant to section 19 of the Contract Act, because claimants' consent to the original SPA were obtained through respondents' fraud and misrepresentation, which also continued through to the closing of the original SPA as amended and so, and afterwards claimant is entitled to compensation to put it in the position in which it would have been, in which he would have been if the representation made had been true. He refers to the Contract Act section 19. On this basis, now kindly see, in addition to specific performance, claimant is entitled to compensation to remove the financial impacts of the discovery of respondents' misrepresentations and fraud. Fraud was just used in the pleadings, loosely used, but now when it is clarified, compensation is for misrepresentation, fraud. Additional damages is for misrepresentation and fraud. Then kindly see 396. In such cases, I'm not troubling Lordship, the court shall award monetary compensation to the claimant accordingly. Indian law thus contemplates, kindly see, awarding both specific performance and damages to provide as much relief. So and so. Putting claimant, 397, my lord, is again very important. Putting claimant in the financial position it would now occupy, but for the fraud and misrepresentation cited above, means awarding claimant the amount of the negative financial impact that fraud and misrepresentation has had. The overall negative impact includes at least. So the damages is only on account of fraud and misrepresentation. Now, my lord, kindly see 397.1. These are the heads. The lost value of the DRC project, then the lost value from the reversed stock split, then 397.3 is another loss. Now kindly come to 398. Now this I must show your lordship because he uses the word breaches here. And I would think, my lord, that breaches would be contractual breaches. Now kindly see 398. As explained below, further in section 5 below, the sum of these negative impacts on the share price of UpHealth Inc. Kindly make a note, my lord, UpHealth Inc. is the holding company, which your lordship would have known by now. Claimant is UpHealth UpHealth Holding. UpHealth Inc. is the holding company. So the negative impact on the share prices of UpHealth Inc., all of which are directly attributable to respondents' breaches, misrepresentation, and fraud, is 122.8 million. Now, let's pausing here for a minute. Kindly permit me to comment that for UpHealth Inc., share prices to come down, first the share prices of UpHealth, the claimant must come down. UpHealth Inc. holding in UpHealth Global is reflected by the value of UpHealth Global. The claimant here
has to be directly related to the...
Yes, 73. He talks of 73, my lord. This is not 73.
Otherwise, they would know that impact would not be relatable to this cause of action.
Yes. He has to first plead that because of your not doing these things, I, the subsidiary of UpHealth Inc., have suffered these losses. That is first which I have to plead. Now, whether that would be the loss which the parent suffered in its share value, whether that is a remote or indirect loss, is a question squarely under 73. But that question is not posed here because he says, I am straight away claiming loss on the basis of the loss which my parent has suffered. So 73 is pleaded, but no remote application of 73. This is one. This is again my third part. Second part of my argument.
Second, yes.
This is the second, but the first is yet there. The lordship will see the first. Now, this is the minimum amount that claimant is owed by respondents to compensate claimant for the monetary damage it has incurred as a result of their breaches, fraud, and misrepresentation. Now, share price of the holding has gone down, and the damage, this is the claimant has suffered the monetary damage. There's no particular monetary damage the claimant has at all suffered. When your lordship sees the award, the so-called expert who came, he gave a more or less honest assessment. The tribunal was not satisfied with his assessment. The tribunal prodded him to make a supplementary report. In the supplementary report, the damages hit the roof, where the share prices of UpHealth Inc. are considered.
But suppose if there is any negative impact on the share price of UpHealth Inc.,
yes,
can that not be constituted to affect the claimant also?
A claimant is a subsidiary. First, my lord, if going by the link, one has to establish a causal connection between the incident of breach and the damages which have been suffered.
The breach was in respect of a contract between the claimant and the
subsidiary.
I'm sorry,
the subsidiary. Let us say
subsidiary
and the award debtor. That is the contract which has
to go through the root of this.
It has to go through the root of the claimant.
The subsidiary.
Yes.
All right.
And then it must be established that because of the loss of which the claimant has suffered, then the parent company has suffered a loss. That is the second limb. Now, whether that is a remote loss or not is a separate argument. Whether I could have foreseen that because the subsidiary would suffer a loss, the claimant would also suffer a loss, whether that possibility was there, that's a separate test. Because once C refers to 73, then that also has to be examined. The forcibility argument has to be tested. And there's no case of forcibility here. I'll show your lordship why. Now, Malad, just because I said, Malad, that breach has been quantified, this is why I wanted to show your lordship, Malad, he uses the word breach here.
Which is here also.
This is, as also explained, this is the minimum amount is as suffered as a result of the breaches. So 122.8 includes now breaches also. As also explained, this is a conservative. Kindly see this, Malad. This is a conservative but reliable calculation.
You are placing from page?
I'm sorry, paragraph 398 at page 205.
Yes, sorry.
The same paragraph.
Yes.
As also explained in section 5, this is a conservative but reliable calculation of the overall loss in value of the respondent's breaches, fraud, and misrepresentation. I mean, kindly make a note, Malad, conservative and reliable.
But
Reliable. So,
but this, if
fair.
Mr. Thakkar, they say it's a conservative estimate,
Yes.
then can't the tribunal give more, the arbitral tribunal give
More?
If they use the expression conservative, do they use that expression in the relief also?
No. Not in the relief. Your lordship, come
Not
back
in.
to the, kindly have the relief side by side.
Yes.
The amended relief now, because we are only concerned with the amended.
Yes.
Conservative was there in 463.4. Conservative is done away in the amended. Or such other amount as the tribunal may deem to be appropriate. Conservative was there initially. Finally, it is not there. So that will not trouble your lordship. Or such other amount as the tribunal may determine to be appropriate.
Yes.
Inquiry into damages. And since this is not an international law contract, I can rely on my knowledge of Indian law to put it in Indian terms.
Thankfully for the court. The court is confident that you would.
I will limit only to Indian.
No, you teach me the foreign law also if necessary.
Okay.
Any of
your lordship is too kind. So,
yes.
So yes. Conservative but reliable here now goes out of the window because the relief is now determined to be appropriate. Of the overall loss in value, respondents' breaches, fraud, misrepresentation have caused to upheld holdings.
So if the word conservative was there, then the tribunal could be liberal.
Right. Your lordship,
it's an anachronism. Yes.
We are not in
conservatism gives rise to liberalism.
So we are not troubled with that.
We are not
but even if it had been there, the court of law would not have been liberal. Court cannot perhaps not award damages more than what is.
Then the quantification is not fixed in, set in stone sort of. The quantum of relief claim, if conservative. Anyway, let us not go into it.
Because
it's not there.
It's not there.
It will be academic.
Yes. And we will read it in the context of an Indian dispute. Might be happening in US, but Indian. Now, kindly come to 208, quantum, which is section 5, which he talks of. So, all this was pleadings in support of quantum. Now, we come to quantum.
Yes.
Claimant is entitled to damages. Then kindly see 406. As discussed in the previous section under Indian law and in addition to specific performance. So the claim is in addition to specific performance.
Yes.
Now I'm not troubling your lordship with the pleadings. Then kindly come to 409. 408 refers to Avitel, my lord. Avitel was a decision on fraud and misrepresentation. So overriding compensatory rule, which is the bulwark of the tribunal's award also is Avitel. The Supreme Court has awarded overriding compensatory rule in commercial transactions for fraud and misrepresentation, not for breach of contract. Breach of contract compensation is Contract Act. You cannot do equity in breach of contract. Now, my lord, kindly see 409 is the expert. Professor Len has calculated these impacts. Now, I'm not troubling your lordship with how he has calculated. 210, your lordship will just make a note, my lord, what are the modes? Discounted cash flow method. These are the methods. So this is 411. Then your lordship will see 417, comparable companies analysis.
Is it necessary
Not necessary, just
to
showing your
know
lordship.
the methodology for the purpose of adjudication? Then don't.
No, the tribunal relies upon it. So I just show
No,
your
no,
lordship.
yeah, absolutely, yes.
Now, my lord, kindly see 428 as summarized.
Yes.
As summarized in the next section, the negative financial impact on Upheld Inc. Kindly see, my lord. This is the holding.
Yes.
The negative financial impact on Upheld Inc.'s share price of the events that Professor Len can reliably tie to public releases of information about local healthcare adds up to 122.8 million. This is the minimum amount, and this is where the tribunal also, my lord, relies on. This is the minimum amount claimant should be awarded in light of the conservative nature of Professor Len's analysis. So this is what is relied upon by the tribunal also, that this is only the minimum. I can grant more. Then cumulative, whether that is
It
permissible.
can grant more than Professor Len's analysis, but not more than the claim.
Not more than the claim. That is what I submit.
Yes, yes.
The cumulative effect, kindly see the cumulative effect of the events linked to healthcare, so-and-so and fraud, and thereafter on upholding was 122. So cumulative effect is 122.8. There is no pleading to support this bifurcation of 1.7 and 122.1. The two figures.
Professor Len's report, is there any?
No, that is just the valuation. That is just for assessment of damages, not on what part is caused by breach of contract or what part is caused by fraud and misrepresentation. So cumulative effect here,
Yes.
and then I don't need to trouble your lordship with the rest. Kindly come to 458. In the circumstances of this case, where the damages to the claimant are measured by the loss in share value of its parent. This is what I was submitting.
Yes.
He repeats it several times. He sums it up here. Claimant are measured by the loss in share value of its parent, and it is unclear whether claimant would have invested this lost value elsewhere. It is reasonable to apply statutory interest rates, etc. He says, grant me interest also. So share value, the measured by the loss in share value of its parent, have caused him so much damage, the parent has gone bust. Thankfully, he's not claimed damages for that now in addition. Then kindly see the reliefs requested at page 235.
No, it is unclear whether claimant would have invested
the money elsewhere.
in line with section 73 or.
He is saying,
because if
share value of my parent is lost, it is unclear whether claimant would have invested this lost value elsewhere.
thereby recovered some of that, maybe that is one of the concept. Anyway.
But even then, knowledge of commercial transactions, share value of parent is lost. For the claimant to invest anything of the lost value, necessarily the parents' promoters would have sold the shares when it was at a higher value, received monies, put it into the claimant, for the claimant to expand its business. Otherwise, how do you realize your share value?
Not directly relatable, you are saying.
Not directly relatable. Today, Reliance Industries holds several shares in several companies. Reliance Industries Limited is the holding company. One of the company's shares, one of the companies suffers a loss by reason of my breach.
Yes.
And the loss has to be relatable to the company's share value going down, as a result of which the parent loses its holding, and that too can be compensated if only the parent.
Otherwise, the numerous children spread over the world will get benefit of.
And the parent has to be shown to, there has to be a case made out that the parent would have sold at such and such date, he would have got so much, did not because of the, all this is remote. 73 is just set for the saying. Then kindly see the reliefs. At 235, your reliefs are what I have shown your lordship. 463.4 was the original relief, then the amended. So this is the only relief which your lordship has seen, in addition to damages. Now, kindly see the award. What has been granted? What they call the dispositive. I'll show your lordship because your lordship has been taken through this several times. I'll just show your lordship, what the disposition is. Page. 570. Yes, 5. Dispositive part, paragraph 423. Till F are the declarations, my lord.
Yes.
G, the tribunal issues a permanent mandatory injunction. This is, my lord, the grant of specific relief. That they will come into the board of the company, the shares will be registered, etc., etc., etc. Then kindly see J. And this is, my lord, what troubles me. So, till I, my lord, from 4, I'm sorry, my lord, G4 onwards, 4, 5, 6, 7, 8, then H and I. So G, all of G, H and I are the, I'm sorry, kindly pause at G, H, kindly pause at G. So G, all of G is specific performance. H is also specific performance. Be ordered to comply with the terms of amendment. So this is specific. H, I, my lord, is damages in addition to specific performance. The tribunal orders so-and-so to severally pay upheld holdings primary damages in the sum set out below. This is the damages in addition to specific. No difficulty, my lord. The amount will come to later. Kindly see down then J. In the event the respondents at any time prior to 30th September 2024 offer to give upheld holdings, the claimant actual control of Glocal Healthcare Systems Private Limited with or without all the assets provided for or contemplated by the SPA, the claimant may forthwith elect to receive control of Glocal and recover additional damages. So specific performance with a cutoff date.
Yes.
This is perhaps something which the Specific Relief Act does not contemplate. And election after decree is, with the greatest of respect, unheard of. Election under 21 has to take during the pendency of the proceedings. This is election after decree with a cutoff date. So this makes it a decree for specific performance executable at the volition of the respondent, subject to election of the claimant. See the two variables, my lord. I hand over control by 30th September. Then the claimant will elect if he takes control and additional damages. This is the decree for specific performance. This optional decree for specific performance is not what is contemplated in the Specific Relief Act by any stretch of imagination. The only cases I've... May I just say one line? Then
yes, absolutely.
The only cases which I have come across while doing this, researching on this point, which my juniors have... Courts have granted decree for specific performance, but they have said that if for any statutory embargo, clearance under the Urban Land Ceiling, clearance under the Income Tax Act, all these were required. If the transaction does not go through by such and such date, the respondent will refund the consideration paid along with interest and damages.
Yes.
There is a statutory embargo involved, not at the volition of the parties. This is at the volition of the parties.
No, refund is a completely different concept altogether.
It's a completely different concept. I can say refund with damages also. Some cases say that is the transaction, rare case.
Refund with interest, I can understand,
Yes,
but damages, not damages.
Not damages.
Refund with interest at best.
Not damages. Refund with interest.
With interest.
Refund with interest.
That's understandable. That's
Yes,
that's the obvious corollary, because if it pays.
Yes.
But this is something entirely different.
This is something different.
That is a new claim. I mean, new sort of.
This is a new relief which was not granted in the first place. This is my third limb. What I just said, my lord, not contemplated in Indian law. This is not contemplated in Indian law. But this is in any event beyond the relief claimed. Where in the statement of claim, my lord, does the claimant make out such a case? I ask myself. Claim is simpliciter, plain vanilla. Specific performance addition for damages. Now we get caramel. Salted caramel.
Salted or assaulted, that will depend on the outcome of this matter.
Well, next.
Next Friday then, yes.
Yes.
21st. এটা একটু সময় অ্যাড হয়ে যাবে এটার সঙ্গে। Harden part for further hearing on
যা রেকর্ড হয়ে গেছে
February 21, 2025.
Only in terms of structures can it retain some priority in the list. It's only one day now that my senior friend is starting, he can maybe come to a conclusion.
No, it's the first part had matter probably. It's the first part. First part had matter. We only put this some content company matters and one or two content matters. Contempt has to take precedence because we give directions to appear. Yes. Yes, from that side. Yes. Division bench. Division bench. Single bench. Sorry. Yes.
My lord, may I be permitted to contempt application, my lord?
Single. Yes. Column list.
Item number 1.
Slight correction and title should not be
Which order? Order dated?
71. The title suit number 464 of 2022 is not been mentioned.
What is the title suit number?
464 of
2020?
2022.
In the order dated January 17, 2025, comma, in the 5th paragraph, comma, after the expression within double inverted district hyphen north 24 Parganas, after the expression eviction suit double inverted মধ্যে, comma, the following will be incorporated double inverted bearing title suit numbers 464 of 2022 double inverted close full stop. Let this order be deemed to be treated as an order as a part of the order dated January 17, 2025. Yes.
Before moving the matter, I sincerely apologize for the morning, my lord.
Pardon?
I sincerely apologize for the morning, my lord.
For what?
For not being able to do a matter which
No,
was
no.
continued.
No, yes. He's appearing for the first time.
He's appearing for the first time, and I would be pressing for an injunction order.
Contempt?
Contempt, yes.
No, no.
But otherwise, it will not.
What is the contempt?
Yes. Your lordship will kindly see my lord's order at page 45.
Oh, they are taking steps on this 13-4.
Yes, and there it's a sale notice which they have published of this property. Despite your lordship, my lord kindly takes a look at my lord page 46, paragraph number 4. In such view of the matter, WPA number such and such is allowed in contest without, however, any orders to go, thereby setting aside the impugned notices under 13-4 of the 2002 Act issued by the respondent bank against the petition, all consequential actions taken in terms thereof by the bank. No challenge to this?
The learned counsel for the petitioner has made out a strong prima facie case for hearing the contempt application on merits, since apparently in the teeth of the order under contempt dated February 5, 2024, which by which the notices under section 13 within bracket 4 of the SURFACE Act impugned therein were set aside, comma, the alleged contender is taking further steps pursuant to the said notice by issuing publications in newspapers for sale of the concerned property in terms of the set aside notices. Accordingly, the alleged contender shall remain restrained from giving any effect in any manner to the aforesaid notices till disposal of the contempt application. The petitioner shall serve a copy on the alleged contender indicating that the application shall be listed next on March 7, 2025 for 7/2025. An affidavit of service shall be filed to that effect by the petitioner on the next date.
We have already served, but we shall serve it.
No, serve again, because you have to serve by
Yes,
virtue of
we shall
direction of court. Keep it with you. Yes.
No, keep it with you.
This is my compliance report. Now, prior to that, I tender unqualified appeal.
What is the nature of the contempt?
Sanction, pension scheme.
Pension scheme. Now it has been sanctioned.
The alleged contentment number 1, Under Secretary has come before your lordship.
Yes, what do you say?
So far, the content number 2 is concerned. She is appearing virtually.
Yes, what is the reason for the delay, Mr. Bhattacharya? Give us. Yes, Mr. Bhattacharya, what is the reason for the delay?
My delay, my lord, departmental process, my lord, they asked for opinion whether SLP is to be filed or not. They got the opinion, my lord, that need not be filed. Already there is delay, so they have complied.
Yes, what do you say?
I believe, my lord, that order has not been complied.
Why?
Because if your lordship kindly come to the second page of the compliance report, that is the annexure R3, second page of annexure R3, paragraph 5.
What is the page number?
My lord, it has not been.
21.
It has not been. I can hand over the copy.
No, we have it.
Or in my copy, এটা তো দিলে ভাই।
Sorry, এটা
But page number 21.
21, yes.
Lord, your lordship kindly see, they have sanctioned the freedom fighters pension, widows daughters pension with effect from 5th of April 24. Lord, that is the date of my lord's order. Lord, I am asking myself, what was my lord's order? My lord's order was to process the application in terms in the as per the scheme at page 35 of my contempt application at page 33, paragraph 16. 35 as paragraph 16. Accordingly, WPA number such and such is allowed, thereby directing the respondent 2 and 3 to take immediate steps for processing the application of the petitioner by treating her to be eligible under the Swatantrata Sainik Samman Pension Scheme 1980 as a widow daughter of the deceased freedom fighter. So, pausing here for a moment, as per the scheme, I am entitled to have the daughter dependent pension with the effect from the next date of death of my father or the mother.
Where is the
Yeah.
scheme? The scheme is also annexed here.
That too, my lord has decided.
এটা দাও দিন অনেক আরে
My lord, that too, in another matter, my lord has decided
দিয়েছি,
that
বস।
is to be followed from the. My lord, I
How
am
many
handing
copies do I
over
need?
also my lord's order. My lord's another order in another matter, wherein my lord's decided it is to be followed from the date of death, from the next date of death. And scheme is even if your lordship kindly peruse paragraph 12.
Seen that. And which part of the scheme?
Paragraph 12 of the scheme. It will be at the last page of the scheme. Except in the case of unmarried daughters, the pension is for the lifetime of the recipient. In the case of unmarried daughters, pension ceases immediately after they are married or become otherwise.
No, this does not say from the date of the death of the.
Oh, my lord's order as page 8 at my lord.
Is that I've seen? Give a copy to Mr. Bhattacharya also.
I have given paragraph 44. Page 9. It starts from actually my lord dealt with from 35, and ultimately my lord held that it is to be made from the next date of death. And they have complied with that same. They have released the pension, she is getting the pension. And that to me, I should be clear to my lord. Even in another case, the Honorable Supreme Court said that from the date of the date, from the date of the application, if at best, if they can raise the question of Koli Indira Kumari, then there was an order from the date of the application.
No, where in the please come to their compliance. That page 21. Where do they say from the date of?
Date of para 5, page number 21, third line.
5, yes.
With effect from 5th.
Yes,
of
Mr. Bhattacharya, it
April
has to be given effect from the as per the law.
If your lordship is so direct, we can do this. We can ask them to do this. Your lordship kindly produce the next paragraph of the page number 36 of the contempt
of the
contempt application. Paragraph 19.
Yes.
There is no ambiguity.
Even the petition is held to be eligible in the light of the above observation, the pension under the scheme shall be commenced to be disbursed in her favor immediately thereafter. This part, my lord, they have to fulfill, my lord, all the documents they have submitted. They have
given now.
এটা রিসিভ করেছেন কি পেয়েছেন কি ওই ডকুমেন্ট যেগুলো 31 31 the documents which was asked to
served upon them, sent to them, my lord, for compliance for the purpose of paying the pension. And after getting that, my lord, it will be clear whether he is completely eligible or not. Thereafter, my lord, discussed.
From which date
It will be given.
But already you have sanctioned.
Sanction, my lord. Your lordship, kindly peruse the sanction letter, other paragraphs. That is very important. Paragraph 9 onward.
Paragraph 9.
Paragraph 8. This sanction will be subject to review by the President of India. In particular, it is liable to be cancellation and modification without any notice if it is found that it was sanctioned on mistaken ground, false information. The government has also full right to recover the wrongly drawn pension in case the pension is cancelled. It is also understood that the pensioner has income not exceeding rupees 20,000 per month or rupees 2,40,000 per year. Yes. If it comes to the knowledge of the ministry that the pensioner has any other source of income exceeding the aforesaid stipulation.
But how could you sanction then in the first place? This is not a provisional sanction. You have sanctioned from 5-4.
Sanction, my lord.
If you have sanctioned, you cannot now resolve from that position and say in the same breath, you cannot give in 100 and take away in the other.
That is also provided in the scheme, always is in the scheme.
No, that is there, it's there. If it's there, it's there.
Therefore, my lord, she will file all the documents which was asked for the purpose of payment. If after
No. His question is that you have said that you have complied with the order.
Yes.
And para 5 says that you have complied, convey the sanction of the president. This is without any rider.
Yes, no.
Subsequently, if something comes to knowledge, then it can be cancelled. That's a different chapter altogether.
But the scheme
But this sanction, whatever is mentioned in para 5, that has to be in terms of the scheme as interpreted by courts. So give it till from the date of the death of the freedom fighter.
Well, you will also kindly observe that in the
I immediately will do that, and we'll give you some time to do that. There may have been some misunderstanding. So how much time do you require? 3 weeks?
In that event, it is to be stated and face order is to be issued.
No, 4 weeks.
Foreign general is to be issued. For correcting the date of the
That they'll
face.
An affidavit of compliance is filed today on behalf of the alleged contemners. Push up next para, learned counsel appearing for the alleged contemner submits that in terms of the order of this court, sanction has been granted for disbursal of family pension to the present petitioner in terms of this court's order. Push up learned counsel for the petitioner, however, points out that the sanction has been given with effect from April 5, 2024, that is the date of passing of the order by this court, whereas the established position of law is that such pension shall be paid from immediately after the death of demise of the freedom fighter, deceased freedom fighter. Push up next para. Learned counsel relies on an unreported judgment of this court in
freedom fighter subject.
yes.
Family member. Because
Dependent.
Deceased dependent member. No. Death of whom?
Death of mother, freedom fighter. She was getting the freedom fighter pension.
Freedom fighter here.
Yes.
An unreported judgment in WPA 14008 of 2023 dated December 13, 2023, where this court had observed that the entitlement accrues from immediately after the death of demise of the husband within bracket, the original freedom fighter hyphen pensioner bracket closed. Full stop. Next para. Learned counsel appearing for the alleged contemners submits that all documents in support of the claim of the petitioner have not yet been submitted by the petitioner. However, sanction has already been granted, subject to clauses 8 and 9 of the sanction letter dated January 31, 2025, which respectively provide that such sanction will be subject to review of the president and is liable to be cancelled without notice if it is found that it was sanctioned on mistaken grounds or false information. Full stop. Next para. Also, it is also provided therein that if it comes to the knowledge of the ministry that the pensioner has any other source of income exceeding the stipulated amount or gives any wrong information or remarriage, comma, the pension shall summarily stop without any intimation and recovery will be initiated by the concerned bank. Post of next para. Be that as it may, comma, such subsequent course of action subject to the discovery of false information has nothing to do with the present compliance of the order of this court. Full stop. Be that as it may, comma, in view of the fair stand taken by the alleged contemner through his learned counsel, inasmuch as the alleged contemner is agreeable to disburse the amount of pension from the date of demise of the freedom fighter, comma,
the next date. For the next date of death of Madhyamala. That is
comma,
30th July.
comma, coupled with the fact that there might have been some
Freedom fighter, no.
doubt in the mind of the alleged contemners, inasmuch as there was no specific observation to that effect in the order under contempt, comma, the benefit of doubt is granted to the alleged contemner, full stop. Accordingly, on the prayer of the alleged contemners, comma, the alleged contemners are directed to disburse to sanction the fresh sanction the freedom fighter pension in favor of the petitioner, not from the date of the order of this court, that is April 5, 2024, but from immediately after the demise of the original freedom fighter. Full stop. Next para, if necessary, comma, such sanction, fresh sanctions shall be granted to that effect. Full stop. The entire exercise shall be concluded within 4 weeks from date, that is within March 14, 2025. Full stop. The matter shall next be listed on March 21, 2025, when a further affidavit of compliance shall be filed by the alleged contemners to that effect.
Subject to one prayer I
Submission of the documents as
one prayer I made.
Needless to say, comma, such sanction shall be subject to all the relevant documents as sought by the alleged contemners being produced,
dated 31st January.
being submitted by the petitioner with the alleged contemner at the earliest, comma, positively within February 21, 2025.
Can it be the 28th?
Very well. By
attestation is difficult.
February 28, 2025. Please start the process, but it will be only subject to 28.
Further personal appearance.
Very well. In view of the above, comma, further personal appearance of the alleged contemners is dispensed.
Application pending, it will appear.
Yes, it will appear on, we have given a date, 21st of March. Atta line at the unreported judgment cited today and a copy of the concerned scheme handed over by learned counsel for the petitioner be kept on record. Thank you. Yes, sir. Yes. Where is Mr. Bagji?
Direction to file.
Malad, I am there, Malad, for the.
Yes, Mr.
petition.
Bagji. What is this? A compliance report?
No, a compliance was filed subsequent thereto, an affidavit in opposition to the compliance was filed, and a rejoinder was also filed to that effect. Now
Right.
the state has also filed a reply. Now, my
Yes.
lord,
There are as many as 5 pleadings, my lord. There are as many as 5 pleadings on the part of the parties. We have filed affidavit of compliance. Opposition filed there too. We filed reply. The moment we filed reply, they wanted to file rejoinder to our reply. The moment they filed rejoinder, we wanted to file a reply.
Wait. One is affidavit of compliance. It started with the affidavit of compliance.
Lordship.
Yes. Then opposition to that
is nomenclature affidavit in opposition itself.
Yes. Affidavit in opposition.
That is number 2.
There was a reply to that.
Reply to that comes, it is nomenclature affidavit in reply, as usual.
Yes.
Then
comes a voluminous piece.
Voluminous rejoinder. Comprising 5 volumes. 5.
No, not that thin, my lord. It's pretty heavy.
রিজয়েন্ডারটা কোথায়? তলায় ঠিক
In reply to those rejoinders, my lord, we have come up today with a reply.
My lord, I shall cut the matter very short.
Yes.
Now, what the state is trying to show, state is trying its tooth and nail to deprive these poor persons who worked as immunization volunteers. Now, my lord, first of all, the issue was the state, first of all, tried to say that these are not immunization volunteers. Your lordship had passed an order directing that in consonance with the notification of the state government as immunization volunteers, they had to be paid. That matter went up before the division bench. Your lordship's order sustained. Subsequently, it was carried up in appeal before the Honorable Supreme Court. Supreme Court did not interfere. They also preferred a review before the Honorable Division Bench. That was also turned down by the Honorable Division Bench. Now, with all these, state is, as of now, still trying to project them as AVDs. As directed by your lordships and several other benches of this Honorable Court and Supreme Court, none of these orders was modified to the effect saying that these are not immunization volunteers. These are AVDs. Now, another thing is that state is trying its tooth and nail to show that this attendance, everything is fake and everything. Now, these persons used to work in block health centers at the ground level in various remote villages. There used to be certain registers wherein they had to self-sign, and the registers were kept within the same block health centers. Now, state is trying to calculate the number of days that they have worked. Let them produce a single sheet of document wherein my attendance transpires. How can they produce those documents? None of the documents, what has been annexed, appended to their reply, shows that the attendance wherein I have signed, they're saying I have worked 2 days a month. On what basis they have calculated on which the amount that they have paid? They have calculated, my lord, for example, a person X have worked for 250 days. On what basis that calculation was done? Nothing. State is trying its tooth and nail to deprive these poor persons. Your lordship had directed payment. Division bench said nothing doing, pay these poor persons first. Supreme Court also said nothing doing, pay them first. Now, this is what the attitude of the state is. But
Yes,
I say I will not go into the deep of the matter. Ask them on what basis they have paid a certain amount, which to us is absolutely a very meager amount, and that does not tantamount to compliance. It is absolutely a colorable exercise on their part just to show that we have complied with the order. But no, a person who is ought to get about 5 to 6 lakhs, he's been given 1,50,000. This is what the attitude of the state is. On what basis that they have given that amount also?
Mr. Bagchi, is it quantified anywhere? What are your respective dues?
Yes, I have quantified it. My
Show me that.
kindly come. My lord kindly comes to my lord kindly comes to my lord my affidavit in opposition to the affidavit of compliance.
Yes.
My lord, page 8 onwards. Each and every persons they made a representations, said that we have got this much amount, this much is due.
But is there any basis to that?
Well, that is what I'm saying. These persons used to work in remote villages, block health centers, wherein there was a registered, wherein they have to self-sign. Some of those registers are also not a prescribed format also. Some of them having
What
a
are these
different
voluminous records? These have been filed by the state. By the
no. I have filed that. I have filed that.
What are these?
Show that these are the attendance register.
These are the registers that were kept. Now, what the state has done, state
Attendance
said this is
register.
fake. Initiated a criminal proceeding against one of the petitioners. I say, my lord, on what basis that they have given this amount? Let them show on what basis they have given.
Mr. Bagchi, how did you get the attendance registers?
That is kept in the block health centers itself. It's lying there. After
So you have taken
lordship
copies. You have taken copies from there only.
Yes, my lord.
All right. Yes, Mr. Gali, what do you say?
My lord, may I respectfully submit firstly, my lord, so far as the question of fact that is concerned, appeal, my lord, admitted, but interim order rejected. That appeal part, lordship.
Appeal is pending still.
Appeal is pending. Secondly, my lord, may I
what about the Supreme Court against that interim order refusal?
That
yes.
disbursal of amount, lordship. My lord, may I respectfully invite your lordship to the order under contempt once. My lord, that is, my lord, at page, my lord, 30 of the, my lord, contempt application. My lord, straight away, my lord, may I respectfully invite your lordship to page 34, the ordering portion.
33.
34. Para 12.
In my copy, it's page 33.
Well, it is the affidavit of compliance is being referred to.
I'm referring to the contempt application.
Contempt application itself.
Content application.
My lord, paragraph 12, in such
12,
view,
yes. Yes.
Lordship, in such view of the matter, directing the respondent 7, the CMOH, to disburse the balance amount of remuneration at the rate of 550 per day accrued to the petitioners for the work done by the petitioner as a immunization volunteers in terms of the order dated December 8, 2020, annexed at page. So this December 8, 2020, Lordship, this annexure your Lordship will find in our reply, my lord. Kindly have a look at our reply. Our reply to the, my lord, affidavit in opposition. Now, Lordship, kindly don't go to this voluminous part. I am on the compliance, affidavit in opposition, and reply there too. Reply, kindly have a look, my lord, at page, my lord, 9 of the reply.
Yes.
This is the, my lord, memo your Lordship was referring to at the time of passing the order. Kindly see the monthly consolidated remuneration of immunization volunteers engaged under immunization programs has been revised. The revised remuneration of immunization volunteer will be at rupees 550 per day for maximum 26 days in any given month. The sanctioned remuneration will be charged, and the revised remuneration will be effective from 1st April 2022. So, maximum 26 days will be effective from 1st April 2020. My lord, our calculation is at page 11. Kindly sees. There are 26 petitioners. The first column is total days worked in 2020, 1st April 2020 to 31st December 2020. Total days worked, next column in 2021, next column 2022, next 2023, 2024. Now total working days Lordship got 327. Total amount paid, as already paid was earlier it was 90. So minus that, whatever paid, amount calculation at 550. So balance was this. Compliance was given.
The last column is unpaid.
This was paid. Because earlier 90 rupees, 550 minus 90.
The total amount paid you have stated 19,580 for the first one.
Yes. So thereafter amount unpaid. Thereafter, yes. Thereafter 1,79,000. So it will be subtracted from 19,580.
So therefore 1,60,000 was the due.
That was the. Now, my lord, we have paid. Yes.
This right hand column entirely you have paid.
Yes.
After my order.
Lordship, I'm showing my. Now I'm back to the affidavit of compliance. Kindly take the trouble, to come to our affidavit of compliance. Affidavit of compliance, my lord. With regard to compliance of petitioner number 127, Lordship has got hold of this affidavit of compliance.
Yes,
Lordship. With regard to compliance, with regard to petition number 127, that is page 19, 19, 127.
Yes.
That is page 19. Breakup is at page 20. Now, with regard to petition number 8 to 14.
Has this gone to their hands? This is
already they have filed opposition.
Yes, ma'am.
They have filed opposition to this. Now, with regard to compliance of 8 to 14 petitioner, number 8 to 14, compliance is page 13. 13. With regard to compliance of petition number 15 to 20, compliance is page 15. And petition number 21 to 26 is page 18. The moment we have put in this, they filed one affidavit in opposition. My lord, may I now respectfully invite your lordship to the opposition file to our affidavit of compliance. In the opposition, they take a point in, my lord, paragraph 6, my lord, clause B. My lord, page 3 of the opposition, my lord.
Yes.
6B says after receiving the partial amount, they say. Partial. Why partial? My lord, kindly clause C. Kindly see the next page. Why partial? The applicants herein have prepared a chart. So, my lord, now, first is representation, page 8 onwards. They start making representation. During the carriage of this content proceeding, they have preferred this representation starting from page 8. Page 8.
This is a carriage of proceedings means before the content
proceeding. They come up with
during
this
pendency of the content proceeding.
This yes, kindly see the date of the presentation starting from.
I'll take your submission on
page 8 onwards. Date is 9th September 2024. What they say, I'm just reading one specimen. এই বিষয়ে যে মামলা হয় উপেন্দ্র মাহাতো সোয়ানসো তাতে মহামান্য হাইকোর্ট ও মহামান্য সুপ্রিম কোর্ট বকেয়া বেতন প্রদান করিতে নির্দেশ দেন। সরকারি নিয়ম অনুসারে আমাদের বেতন বছরে 1,71,6,000 মাসিক, দ্যাট ইজ 515 to 26 দিন এত টাকা হয়। During the carriage of proceedings, these representations come, and finally, they are coming with a computation summary of all the petition at page 34. So, my lord, during the carriage of proceedings, they are trying to change the tack. Your lordship's order was to pay in terms of the revised memo. The quantification was not made. We have given them. Now, during carriage of the content proceeding, they are coming up with
not irrespective of their subsequent representations. Previously, also they had given representations.
No, only to get that we are not being paid on the basis of
quantification.
No quantification. Now, Lordship, may I respectfully rely on judgments? Lordship knows me not at the cost of castigation. I am relying upon these judgments. My lord, this is my lord.
This is not a fresh representation, Mr. Galib. This is a quantification of that.
That cannot be. Since the direction under there is order and conduct was you pay.
My order did not quantify any amount.
Here on that particular proposal, there is specific judgment of the Honorable Supreme Court Lordship. May I respectfully invite attention to your Lordship, that is of 2021, volume 17, SCC, my lord, 813. Report, Judge. Breach of which the order is alleged, kindly have a look, my lord, at page 3. First, the breach of this order was alleged. The breach alleged in this content petition is of the direction contained in paragraph 73 of the aforesaid judgment of this court dated 7 July 2015, which reads thus. See, the Depotor board is occupying some part of the emphasis. I'm reading out on
second and peaceful opposition.
The parties representing Depotor are already also directed to hand over the vacant and peaceful possession of the premises concerned and other properties or temple, if any, within 4 weeks from there. This breach of this order was alleged in this particular contempt. What the Honorable Supreme Court says, my lord, kindly sees, my lord, at page 9. We have given care, Lordship, page paragraph 9, Lordship. We have given careful consideration of the submission. We have already quoted paragraph 73 of the judgment dated 7 July 2015, which contains effective direction. Perusal of the judgment shows that there is no discussion there about the liability of respondent number 1 to pay in specific amount. Para 73 refers to premises and other properties of Kamakha temple. However, there is no finding recorded that any particular amount is payable by respondent 1 to 4 of the petitioner. Para 10. The learned senior counsel appearing for the petition pointed out that immovable property of so-and-so as well as other subsidiary temples have been handed over to the petition in terms of so-and-so. Though there is no specific direction in paragraph 73 to pay any amount, reliance is placed by the learned senior counsel appearing for the petitioner on the order dated 31st January 2020, which we have quoted above. That quotation is, my lord, at para 6. That is different report by some ADG. So now what the Honorable Supreme Court says in paragraph 11, my lord, kindly sees. Placitum C part important, paragraph 11. Moreover, the observations in the report cannot be treated as concluded findings, even assuming that para 73 of the judgment dated 7 July 2015 includes a direction to pay amount. There is no adjudication made to decide what is the extent of liability.
But this judgment is not applicable.
Extent of liability, my lord, extent of liability.
In paragraph 73, in that case, only peaceful possession was, there was a direction to hand over possession only.
Only?
There was no direction to pay any money.
No.
But this court's order in the present case is only to pay money.
Pay, but not the quantification. My lord, here.
There was a question of quantification here because there was no money decree at all. It was only a direction to hand over vacant and peaceful possession. They relied on a subsequent report. Supreme Court said that that report is immaterial.
Immaterial, but even if it is said, my lord, even if it's even assuming that para 73 of the judgment dated includes a direction to pay money, assuming all the handover property was the direction, but Supreme Court is assuming, I should not interpret in this way, my lord, kindly I bid mercy for. Even if it assumes direction to pay money, there is no adjudication with regard to quantification.
No, there was an adjudication in this case to pay money at the particular rate.
And, my lord, And my lord, second judgment, my lord,
That is
representation, my lord. No, no,
representation only quantifies the amount. They say you have not paid the entire amount.
No, but lordship, representation, they are making a new cause of action altogether.
No.
Lordship.
Cause of action was already there. They rely on that direction of this code and come to any of the pages. They say that সরকারি নিয়মানুসারে আমাদের বেতন বছরে such and such মাসিক 550 into 26 দিন. So they have quantified in terms of your calculation 26 days.
No, they have not. All the ABDs or Milord volunteers never worked for 26 days. Somebody to that I'm in the next point, my lordship. Kindly comes to my reply to the rejoinder.
Then after your lordship's order of directing, observing them as immunization volunteers, state is
Milord, there is firstly my first full submission is my learned friend has annexed so many attendance, so-called attendance register. There is no attendance register as such of any Milord volunteers.
And how did they quantify the amount? How they have paid us?
They are all forged. Kindly have a look, my lord.
Well, let them show the basis on, my lord, we will return the amount if there is no basis.
I will show the
How on what basis that they have paid? But I'll show your lordships on what
I will
basis
show
they have
the basis.
paid.
What is the basis of our calculation, my lord?
Yes.
My lord, kindly have a look, my lord. Kindly see page 65 of volume 1. I'm just taking volume 1. Page 65.
Yes.
Attendance register of teachers.
But these are all
unstamped. Unstamped, nothing of the sort. Our ground is forged and fabricated because there is no such.
You produce your attendance register then?
Yes.
How do you quantify?
No, we don't.
What is the basis of your calculation? Then?
Yes, I will show. That is so Milord, may I just place this? So he has, Milord, annexed all these up to page 112. Lordship will see the same thing. Up to page 112. Thereafter, from 113, he shows.
If there is no separate attendance register for this immunity volunteer,
We are calculating.
then you must
now,
have
Milord,
been taking attendance.
I am
you must have been taking attendance on the teachers.
I'm showing our basis. I'm showing our basis.
Book
Now,
or
Milord,
whatever.
in my respectful reply to the query of this Honorable Court, what is the basis? Basis is number of working days, how identified. That is, Milord, para 8.
Of
We have
what?
stated.
Of
Our, Milord, reply to the Milord rejoinder. Kindly have a look at para 8.
ABD.
Mr. Bakshi, please don't interject.
Madam.
Yes, Mr. Kali, please continue. Para 8.
Para 8, Milord, it is. May I read out, Lordship?
Of the reply?
Of our reply to the rejoinder. Not affidavit in reply, Milord. Reply to the rejoinder. The last one which I filed today, Milord.
Yes.
Lordship. Para 8, Milord, may I, Milord? It is apposite to mention here that during such vaccine and SC vaccine intent form, that is indent form are issued under the seal of block medical health officer, which are signed by the AVDs while receiving such vaccine. It is from such record that the authorized authorities identified number of working days of each AVD.
What is AVD, Mr.
AVD, Milord, it is alternative vaccine deliveries. And kindly, Milord, I have annexed, Milord, this specimen of this SC vaccine indent forms from page 77. And I have craved leave also, Milord. Craved leave. A sample format has been given.
No, what about these of these particular people? I mean, how do you get it?
Madam, may I interject for a while? 1 minute.
No, please don't.
Kindly see page 77 once, Milord.
77, yes. This is
kindly see Radhesham Mahato, that is left hand side, there is a signature.
Yes.
So this is how the
He's one of the petitioners.
One of the petitioners. This is how, Milord, yes, this is one of the petitioners. Milord, this is how we, Milord, this function of these people, Milord, as your lordship, vaccine days and polio days are their vaccine. So these people are engaged only to carry the vaccine from the cold chain to the camp where the vaccination goes, carried on. So this is the function of these people. They carries from cold chain. So, Milord, these are the basis on which we can calculate their working days. We have produced, Milord, the format of Indian form, some up to page 79. Some of the petitioners' Indian forms have been shown over here. So if required, Milord, we have craved leave to if it's a voluminous document, we can produce. So on the basis of this, we come to the number of working days which have been put in by the petitioners in this case. This is the basis. And my lord, secondly, my lord, we have annexed another set of document at page 45. Where from page 45, my lord, collectively we have annexed document that is RI micro plan. Page 45 of the same, my lord, reading. This shows that an EVD, he works, my lord, 2 days a week, not more than that. This is what we have stated in paragraph, my lord, 6. Kindly see, my lord, paragraph 6 of our this. I state the claims of the petitioners for working of 26 days in a month are incorrect. At a stage, they never work for 26 days. As per the routine immunization micro plan documented in R1 Form 13 related to vaccine distribution plan, it is clearly outlined that AVDs worked for 2 days in a, that is not month, in a week, 1 day. It should be week. At the sub-center and 1 day at outreach sanction. 7 except the same, there is no provision to issue vaccines from block PHE level cold chain points to the sub-center health and wellness center, except the vaccination day, which is, that is 8 days a month. AVDs have no duty to perform. So until unless, my lord, the cold chain is giving them, there is no question of getting, my lord, the vaccine, so that they will not. So, and naturally, they are also without any work. So maximum 2 days. So, my lord, and one worker does not get 26 at a stretch to work. And, my lord, thirdly, with regard to the, my lord, attendance register of Upen Mahato, which he has annexed, these are signed. My lord, we have specifically stated in our affidavit, Upen Mahato has stolen the ASHA attendance register from one sub-center. That sub-center I have annexed. He has stolen and committed forgery. For that, my lord, that we have stated. For that, we have, my lord, lodged an FIR against him, so far as Upen Mahato is concerned only. That is, my lord, we have said in paragraph at page 15. And we have stated, my lord, in our paragraph also, my lord. Kindly have a look at paragraph, my lord. So, my lord, Upen Mahato, we have stated, my lord, may I respectfully invite your lordship.
It's also there in my rejoinder.
To paragraph 12A of our affidavit. Page, my lord, 6. I say the reply from the BMOH, Jolda, along with written statement of the health assistants and CHO. CHO is Chief Health Officer. As indicated herein above, would clearly indicate the documents annexed here to are false and fabricated. It is repeated and reiterated that there is no register as sought to be annexed by the applicants herein or maintained by the department for the AVDs in such format. The attendance is recorded through SC vaccine indent form, which I have referred to, my lord. A specimen already annexed herein above, which are already annexed at Annexure I. However, it is apposite to mention herein that with regard to the case of the applicant 1, that is Upen Mahato lordship, he has stolen the ASHA attendance register from the sub-center and had entered his name and signed on all pages. The concerned community health officer had immediately addressed the
What is that ASHA attendance register? In which page of these volumes?
That Upen Mahato's attendance
Give us the
register.
page number. Which volume and which page?
Not sure. He has not annexed that. And we have said it is presently the original ASHA is, my lord, may I have a, my lord, may I travel your lordship with page 15? 1.5.
Marker.
If he has not produced, then how? What is the relevance of this averment here?
As because he has taken a point.
That ASHA attendance register.
That we are against me, against Upen, since I am the flag bearer, I am the whistleblower. So one
is the petitioner number 1, yes.
That is the first impression. That's why if I has slapped on me,
that is the first impression the court also gets.
Lordship.
Because so, it's the petitioner number 1.
So, first, my lord, kindly, my lord, may I travel your lordship with page 13 first?
Page 13 of this.
Of our, that same, my lord, reply I am telling you. First, we shot off a letter to all the BMOH at page 12. In reply to that, they are giving replies. So, again, Upen, what does the BMOH say? Kindly see at page 13. In reply to a letter, we had a memo number so and so. The BMOH or Jalda willing to state you that attendance register submitted by Upen Mahato under Jalda is not valid, and already an FIR has been lodged by the health assistant and CHO for theft and forgery of staff attendance register of Cookie SC by Upendra Mahato. And thereafter, my lord, kindly have a look at page 15. This is the statement at 1.5. At 1.5, the Kalpana Mahato health assistance of the center is writing this.
Yes.
And so far as the other one, another register you will find that Bipin Pramanik.
What about that?
This is not the, because we don't have any Miller attendance register with regard to ABDs. This is Bhakti Bodo Pramanik Lordship will find from volume 1. Volume 1.
Yes.
Bhakti Bodo Pramanik, that is another petition. He has annexed certain attendance register.
Yes.
From 12 to page 64, Lordship will find.
Yes,
What
yes.
do you say about that? Kindly seize, my lord. What has he done? What we have said about Bhakti Bodo Pramanik, my lord?
There is some signature of some medical officer of
Lordship, he is what he is. He has shown, he has brought this. Kindly have a look, my lord. May I travel your lordship with page, my lord, 81 of our, my lord, the same, my lord, reply to the rejoinder. '81, my lord, of our, my lord.
Yes.
Reply to the rejoinder. 81. The Ononna Prathya medical officer is writing to Chief Medical Officer of Health. I, Dr. So-and-so, am writing this letter about certification of the attendance register of Mr. Bhakti Bodo Pramanik, who has been serving as a...
So this is in respect of different projects.
Different. So this reply, my lord, the answer regarding Bhakti Bodo Pramanik starts from 81 and, my lord, ends up to 89 of our reply. And rest of the...
this is that same, the reproduction of the same, I mean, from the BM.
That is his attendance register with regard to Group D staff of, my lord, of Rogi Kalyan Samiti.
Right.
So that is not the attendance register of ABD, because with regard to, my lord, volunteers, we do not have. Our only way to calculate is that indent form. And, my lord, micro
indent form shows you how many vaccines were delivered.
We have calculated. That is why we have given the calculation, my lord, in our reply to the affidavit that at page 11 at the very outset I have shown reply to the affidavit in opposition, and as well as in the compliance also the breakup.
Yes.
Kindly, my lord, sees only, my lord,
yes.
Our reply to affidavit in opposition, my lord, at page 11 we have given the breakup.
Yes.
All these 26, my lord, we have named in the second column.
Right.
And these are the amounts paid. As well as this breakup also, lordship will find from our affidavit of compliance. I refer to different pages.
Let us hear them, what they have to say.
So, my lord, kindly, my lord, take our, my lord, only, my lord, I shall, my lord, kindly, my lord, we have taken also certain points, my lord, that kindly have a look at, my lord, paragraph 14, my lord, paragraph 14 of our, my lord, reply, my lord, reply to the rejoinder.
Yes.
Page 9, my lord, the continuation of paragraph, my lord, 14, my lord, page 9, last, my lord, 5 lines, my lord. On the contrary, the sentence starts with, my lord, on the contrary, some, my lord, kindly take cognizance of these, as well as, my lord, paragraph 16, my lord, paragraph 15, my lord, and 16, my lord. Kindly take cognizance, my lord, because all these are cycle-styled, my lord, done from a particular store. I don't know the same, lord, all these, and register, my lord.
Now, my lord, first of all, my lord, I would say from the respective pleadings, what has been taken by the state, my lord, it's an attempt, my lord, to overreach the court. Kindly comes to, my lord, the contempt application, page 34, your lordship's order. Kindly takes up the contempt application for a while, page 34.
Yes.
My lord, kindly comes to paragraph 11. Your lordship has held that being immunization volunteers under the concerned scheme, my lord, whether this order has been set aside, whether this portion that these persons are not immunization volunteers, has this part being set aside? How in each and every paragraph the state is describing them as alternative vaccine delivery, AVD. It cannot
immunization by its very concept incorporates
AVD,
the concept.
My lord, and immunization volunteer, state is trying to discriminate between the same.
Vaccination.
It's not the same.
Vaccination is immunization. What is
No,
the
my lord,
difference?
as per notification, immunization volunteers are entitled to 26 days a month work of rupees 550 a day.
They are not denying that you are entitled to 26 days out of
No, what they're
each
saying,
month.
they're saying we are AVDs. We are not AVDs. We are all immunization volunteers.
Sorry to interrupt. Kindly see paragraph 10 of your Lordship judgment under contempt.
Yes, yes.
Lordship was pleased to dub them as
No.
by the respondent, the PDO were engaged in AVDs, alternative action delivery persons.
No, kindly
That
see,
has been
as such the
disbelieved.
reasons as
That has been disbelieved.
yes.
That
Your
has been
lordships
disbelieved.
disbelieve, and your lordship says that these are
That has been
immunization
disbelieved.
volunteers.
Yes.
So, question of working 2 days a month, but it cannot be. But what documents that they have appended does not bears the
What
signature.
was the nature of job you did, Mr. Bagchi?
Yes, that is most important. We used to bring vaccine and you used to work as immunization volunteers. We used to accompany persons and each and every day you used to work. We are not persons who are going to take these things and keep it in our home, in our fridge.
No, but you also, every day you are saying, but you also in your representations have admitted that you are entitled to 26 days a month, which is in line with
26 days a month. But my lord, the ground
ABD.
situation is we work more than 20. We are not saying as per notifications we are entitled to what we are.
Yes. No, Mr. Bagchi, the difficulty is the contempt court cannot go into these disputed questions of fact. Then we'll give you
What
liberty
I'm
to
saying, my lord, state,
you
my lord,
file a
with
civil
regard
suit
to
for the balance amount because you have already been paid 1 lakh, almost 1 lakh or more each. Some have been paid less, but some have been paid more also. So you for the balance, this amount, this disbursal is not disputed by you. The balance amount will give you. I'll give you leave to approach a civil court. We
kindly
cannot take
consider,
evidence.
my
We have
lord,
to take
my lord,
evidence on this.
no, your
Contempt court
lordship,
it is beyond the jurisdiction of
no.
contempt. to go into
What
this.
I humbly bow down before your lordship. But my lord, but this attempt by this showing tooth and nail, everything, they're trying each and everything to deprive this person. Now, my lord, I say on what basis that they have paid the amount. When annexing 1 or 2
They
documents,
have
my lord,
given some basis, Mr. Bakchi. They have given some basis that the basis
no,
is
my lord, 2-3
is
persons and
the
only
carriage of
think
the
that their persons
carriage
are
of
bringing.
the carriage of the vaccinations and all.
Yes, only my lord, 2-3 pages, 2-3 pages, 2-3 pages. Well,
You
I say
approach a
that
civil
even
court for the balance amount. Approach a civil court if you are entitled.
let them compute and
The
calculate
contempt court
whether
cannot take evidence. Sorry.
your lordship will not take evidence, my lord. I humbly bow down before your lordship, my lord, with those 2-3 pages, my lord. My lord, the computation itself has no
Yes,
basis
let
of
me
the
pass my
state.
order, Mr. Bagchi.
My lord, kindly
The-
consider, my lord.
The pleadings of the parties run into several pages. Full stop. In answer to the contempt application, comma, an affidavit in opposition and a reply was filed. Full stop. Thereafter, an affidavit of compliance was filed by the alleged contender, to which a rejoinder was taken out by the petitioner and a further reply thereto filed by the alleged contender. Full stop. Next para. The pith and substance of the argument of the petitioner is that the petitioners, comma, although paid a meager amount, comma, have not been paid their entire dues. Full stop. It is pointed out that this court had directed the petitioners to be paid the balance amount of remuneration due to them at the rate of rupees 550 per day for work done as immunization volunteers. Full stop. The plea of the alleged contender was turned down by the writ court to the effect that the petitioners are alternative vaccine delivery AVD capital persons. Full stop. Next para. However, comma, the alleged contenders now seek the alleged contender now seeks to portray that the petitioners were alternative vaccine delivery persons, comma, contrary to the order of this court. For next para, it is further submitted that voluminous copies of the attendance registers of the petitioners, comma, while acting in the capacity of immunization volunteers, have been filed in court. Full stop. Next para, such attendance register, comma, it is submitted by the petitioners, comma, is maintained with the concerned block development officer, from where they were copied. Full stop. Next para.
No, block health, it lies with the block health centers.
Block?
It lies like block health centers, wherein the
Sorry,
health
the block
centers.
health centers. Block health center. To the next para. It is further argued that the alleged contender has failed to disclose any basis of calculation of the dues of the petitioners. Full stop. Further, comma, the alleged contemner has wreaked, WREAKED, vengeance against the petitioner number 1, comma, since he was at the forefront of the contempt application and the writ petition, comma, by lodging police complaints and registering FIRs against the said petitioner. Full stop. Next para. Learned counsel for the alleged contemner places reliance on the annexures to the pleadings filed in respect of the contempt application by the alleged contemner, push up in the affidavit of compliance as well as in the affidavit in reply filed by the alleged contemner, comma, the detailed particulars of the payments made to each of the petitioners on a calculation of rupees 550 per day, comma, taking into account that the entitlement of the said petitioners can at best be 26 days a month, comma, has been reflected in the said annexures. So it is further submitted that none of the petitioners worked for the entire period of 26 days, comma, rather they did the work akin to alternative vaccine delivery persons, whose, comma, the nature of work being to take the vaccines from the cold chains to the respective locales as required. Full stop. Next para. In support of his contention, comma, learned counsel for the alleged contemner places reliance on annexure I to the reply to the rejoinder, comma, where sample indent forms for SC vaccines have been disclosed. Pushed up, it is submitted that such indent forms form FRM the premise of calculation of the work actually done by each of the petitioners. Push up. Next para. Insofar as the attendance registers are concerned, comma, learned counsel for the alleged contemner takes the court through several documents annexed to his pleadings and argues that the said registers are manufactured documents. Full stop. In fact, comma, some of the said registers were procured by at least one of the petitioners, comma, for work done in respect of a different concern, comma, relating to which letters from the authorized representatives of the said concerns have also been annexed. Full stop. It is further reiterated on behalf of the alleged contemner that at no point of time was any separate attendance register maintained for the petitioners who acted in the capacity of immunization volunteers stroke alternative vaccine delivery persons, and as such, comma, there is no scope of placing reliance on any such attendance register to ascertain the work done by them. Full stop. Next para. Learned counsel for the petitioner vociferously opposes such contention and argues that the alleged contemner is trying to bypass the order of this court, comma, which has been affirmed in appeal and thereafter in an SLP preferred before the Supreme Court. Full stop. However, comma, learned counsel for the alleged contemner points out that the SLP was preferred only against an ad interim refusal of stay of the order of this court of the appellate court, and as such the main appeal against the parent order is still pending. So be that as it may, comma, I find from the records that voluminous documents have been relied on by both parties which require assessment on evidence being taken formally by the court. Full stop. Next para. Such detailed disputed questions of fact cannot be entered into by a court sitting in contempt jurisdiction. Full stop. The alleged contemner has also placed reliance on a judgment of Namta Diye Deben, reported at 2021-17 SCC 813. Full stop. However, comma, in the opinion of this court, comma, the ratio laid down in the said judgment is not germane in the present context. Full stop. In the said case, comma, a direction for handing over of vacant and peaceful possession of an immovable property was given by the court initially, upon which the petitioners therein had alleged that the due quantum of the petitioners had not been paid by the alleged contemners. Full stop. The Supreme Court observed that there was no quantification of any specific amount or liability of the respondents therein to pay such amount in the original order. Full stop. It was further observed that even assuming that there was such a direction to pay money, comma, there was no adjudication to decide the extent of liability. Full stop. In the present case, comma, however, comma, the extent of liability was clearly specified to the effect that the petitioners were to be paid at the rate of rupees 550 per day of work done by them. Full stop. Also, comma, the present parent order from which the contempt arises did not pertain to any immovable property, but specifically related to a direction to pay money to the petitioners in terms of their dues as work done as immunization workers, volunteers. Full stop. Next para, be that as it may, comma, in view of the above observation, comma, this court is not convinced beyond doubt that the alleged contemner is in contempt of the order passed by this court. Full stop. A reasonable basis of the quantification has been furnished, comma, irrespective of the veracity of which, comma, the said question cannot be gone into by this court. Full stop. Next para. In such view of the matter, comma, as per the well settled proposition, legal proposition that the extreme measures of contempt cannot be taken if there is an iota of doubt as to willful and deliberate violation of the order of the court, comma, the contempt court is not in a position to hold that the alleged contemner has deliberately and willfully violated the order of this court, comma, particularly in view of some reasonable basis having been shown for the quanta of amount subsequent disbursed subsequent to the parent order in favor of the petitioners. Full stop. Next para. As such, comma, there is no scope of keeping the contempt application pending. Full stop. Accordingly, CPN 377 of 2024 is disposed of. Full stop. WPCRC 65 of 2024 is discharged in terms of the above order, comma, dispensing with further personal appearance of the alleged contemner. Push up. Next para. It is made clear that irrespective of the observations made above, comma, it will be open to the petitioners to approach the appropriate civil court for claiming the alleged amounts, comma, if any, comma, still due to the petitioners from the respondents in the original writ petition. Push up. If so approached, comma, the concerned civil court shall upon giving opportunity of hearing to both sides and upon considering the evidence furnished by the parties, comma, decide the issues involved in accordance with law without being influenced in any manner on merits by any of the observations made herein and or the disposal of the present contempt application. Full stop. No orders to cost. Thank you.
Pleased.
5 Milord, I beg to represent the alleged contemner, Milord. Last direction was that you are to comply within, kindly have a look, Milord, on the date, order dated 31st January.
Due amount by February 12th, yes.
We have already, Milord.
Yes, for this.
By 4th February 2025.
So far, my lord, the relating to the interest part has not been, my lord, the
interest was not directed. Was it
No,
directed in the?
No.
directed.
Kindly see
Leave
page
be
34.
granted so that, my lord. But since the amount was withheld for a long period,
We cannot, in contempt, you cannot pass further orders.
no, only for leave if so advised.
No, it was decided finally. There was no interest granted.
That is true.
That is not open. Learned counsel appearing for the alleged contemner. The alleged contemner is present in court today.
No, there was no, Milord.
No direction. আচ্ছা আগের ম্যাটারটা না প্রথম লাইনে একটা করে দেবেন, the alleged contemner is present in court today. এটা এবার Eternal.
There was no rule against that.
Previous, no, he was present in court, you said? In the previous matter.
No, there was.
You showed somebody he was present?
No,
you said that.
Item 3, somebody. Oh, item 3, yes, some personal.
Item 3, sorry.
Item 3, my lord. In item 3, there was personal.
হ্যাঁ না ওটা তো হবে আগেরটাই তো আমি ফার্দার পার্সোনাল ওটা তো একটা রুল ইস্যু হয়েছিল না ওটা থাকবে ইন আইটেম 3 হি ওয়াজ পার্সোনাল প্রেজেন্ট
দ্যাট ওয়াজ নট মাই ম্যাটার
যা এটার অর্ডার নেই আর এগুলো যা আছে থাকবে learned counsel for the alleged contemner hands over communication dated February 12 2025 that pursuant to the order of this court dated January 10 2025 the due amount has been paid to the petitioner within
on 4th February.
Now on February 4 2025, that is much prior to the timeline stipulated by this court, that is February 12 2025. Next para, such communication be kept on record. Learned counsel for the petitioner submits that due to long withholding of the amount, interest also ought to have been granted. However, since there was no direction to pay interest in the parent order, the contempt court cannot go beyond the jurisdiction of its domain and carve out any further relief in the parent order. In view of the compliance as indicated above, WBCRC 135 of 2024 is discharged. Personal appearance of the there was no direction.
He did not. There was no.
Next para.
May I pray for one sentence in the order, my lord?
1 minute. Accordingly, CPAN 1101 of 2024 is also disposed of. Yes.
Lord, there was an appeal from this order, stay rejected, but appeal admitted. So, my lord, may I pray for one line in this or subject to the, my lord?
Next para, since an appeal.
Hand over this copy of the appeal order.
Since an appeal is pending against the parent order, it is made clear that the disbursal of the amount in favor of the petitioner shall be subject to the outcome of the said appeal and will be without prejudice to the rights and contentions of the parties in the appeal.
Great.
You're appealing, Mr. Ghosh?
These are two analogous matters, my lord. Application filed for restoration was dismissed for default. Mr. Bimal Kumar Chatterjee was an advocate on record. He expired long back, my lord. So this first two applications, my lord, are for restoration.
Application.
There are two analogous matters.
Two appeals, two separate.
What I am saying, my lord, let the appeal be restored and be placed for hearing.
The restoration applications have been filed beyond time. 12 July 2024 and filed on
12 July, my lord, the order was passed.
No, within time. No, beyond time. Beyond 30 days. Beyond 30 days. So we'll continue. What is the reason given that?
My lord,
Mr. Bimal Chatterjee was still their advocate when?
No.
Then?
My lord, when the matter was dismissed for taken up and dismissed for default, long before that, my lord,
Mr. Chatterjee had expired, but somebody else was engaged in his.
No, after that.
That is what I'm asking.
Along with the application.
So the current advocates, along with the present.
My lord, what I am praying, my lord, if the matter is restored and the appeal, both the appeals be placed for hearing, this is the assignment. Short matter, my lord, FMA remand order.
Mr. Ghosh, you don't know how many short matters are already pending in the list.
No,
short first appeals are pending in the list. And we are deciding some in open court because those can be, but there are too many. We cannot add right now. But if it's an assigned matter, it will appear under the assigned heading next month list.
Next monthly list.
Yes. March. Can 2 of 2024, both same ground?
No.
Acha. The two applications are taken up for hearing together. Full stop. Can 2 of 2024 has been filed in connection with FMA 92 of 1991. Full stop. I find from the averments made in the application that the erstwhile learned advocate appearing for the appellant stroke petitioners had met his demise long back, and as such, the appellants were not in a position to be represented when the matter was taken up for hearing and dismissed for default. Push up next para. A similar explanation has also been given in respect of Can 3 of 2024, which has been filed in connection with FMA 91 of 1991, where the learned erstwhile advocate was the same as in FMA 92 of 1991. Full stop. Being satisfied of the sufficiency of the absence of the appellants on the relevant date, as well as for the delay in filing the applications, Can 2 of 2024 is allowed, you have served notice on the other side.
Notice of appeal was served
No.
on respondent number 1, but so
No,
far
on
as
the date when the matter was dismissed for default, they were not present. Then order
there
904,
is,
please, sir.
there is no appearance either.
Can 2 of 2024 is allowed, thereby recalling the order dated July 12, 2024 and restoring FMA 92 of 1991 to its original file and number. Full stop. Can 3 of 2024 is also allowed, thereby recalling the order dated July 12, 2024 and restoring FMA 91 of 1991 to its original file and number. Full stop. Next para, it is made clear that in view of there being no appearance on behalf of the respondents as well on the date when the appeals were dismissed for default, following the principle of Order 9, Rule 4 of the Code of Civil Procedure, prior service of notice of the application on the respondents is not insisted upon. Full stop. Next para. Let the appeals be placed under the heading Assigned Matters together in the monthly list of March 2025. Thank you. সেটা ডিসমিস হয়েছিল না না কিন্তু এটাতে রেজিস্ট্রেশন আছে মানে রেজিস্ট্রেশন এখানে স্যার yes Mr. Rokit, yes it was dismissed for default on
the Lojima bench, it was dismissed for default.
For default or for non-compliance of any court order?
No, dismissed for default.
Thank you. Oh, long back.
Yes.
No, it was recorded that in spite of repeated directions, the petitioner has not taken steps. What steps?
No, my lord, it appears, my lord, that there is also an application for substitution. Can 5.
Oh, for that, no steps were taken.
Yes.
But then you serve copy and come back.
Copy, my lord.
Substitution and restoration have to be allowed together then, because they were dead at that point of time. So you have to simultaneously, on the date when the revision was dismissed for default, Mr. Rokhi,
yes,
the persons who were sought to be substituted, they had already died then.
Respondent number 2
had died then already. Or
He
died
died.
subsequently.
Yes, just a minute. He had died, my lord, on
Yes, before that, 19th of May 2011, you have stated?
19th March 2024.
2024, subsequently.
Yes.
And restoration was filed within time?
Yes.
Within time?
Yes.
So you have to serve copies of both on the opposite party?
Restoration. Restoration and the
substitution you have to file, serve.
Substitution within time.
Substitution is within time, but the other side may come and say these are not the legal errors. You have to serve copy of the application.
If it is within time, if it is within time,
Achha. And restoration on that date was the opposite party represented? Let us check.
Respond number?
No.
No, no. Non-appeals
Very well.
petitioner.
Can 5 of 2024 is an application for substitution of the heirs and legal representatives of the original opposite party. What was the opposite party number? Defendant number 2 you have stated.
Defendant number 2.
What was the opposite party number of that defendant? Of the defendant stroke opposite party number 2, Jagannath Shao.
Yes, Jagannath
Shao.
Shao.
Next para. The application is in time and otherwise informed. Accordingly, can 5 of 2024 is allowed, comma, thereby directing substitution of the heirs and legal representatives of late Jagannath Shao, comma, the original opposite party number 2, comma, in his place and stead as opposite parties in the revisional application. The necessary consequential correction shall be carried out by the learned advocate on record for the petitioner during the course of the day, Mr. Rokhi. During the course of the day, you'll carry out the correction. You'll carry out the correction in the revisional application, the names of this person during the course of the day. Next para. What is the new number of CAN 4929? Is there a new number?
And 4?
Thank you. Can 4 of 2018 within bracket old number can 4929 of 2018?
Yes, 4929.
29 of 2018 is an application for restoration
Restores the original CO.
of CO number 4758 of 2006. But this was beyond time.
No, if it is restoration, my lord, which
30 days.
Filed within 30 days, and whether it was filed on
16th of July.
16th of
Much beyond 30 days. CO number such and such. Order dated বলেছি February 20.
No, CAN 428 is an application for restoration of C.
Comma, which was dismissed for default by an order dated February 24, 2012. Full stop. Next para.
Regarding 4928, section 5 is there.
4929 we are taking up.
Yes. 28.
28 is the section 5.
Yes. 286 section 5.
Say that. What is the cause of the delay?
Cause of the delay is blood. Missed the matter in the list 25th February. As such, could not take steps.
But section 5 and the other the restoration, then you have to serve copies. The delay has to be condoned. Without hearing them, how can you?
As you will.
So can 4928 of 2018.
Yes.
Within bracket at present. CAN 3 of 2018, comma, is an application for condonation of delay in filing the said substitution application. Next para. The petitioner shall serve copies of the said applications on the opposite parties and the substituted opposite parties, indicating that the applications shall be listed for hearing next on March 7, 2025, when an affidavit of service to that effect shall be filed by the petitioner. এগুলো কি অ্যাসাইন আমার কাছে রিট পিটিশন item 9, who is appearing?
Item 9, my lord,
Do I have jurisdiction? I don't have jurisdiction. Only assigned matters I have jurisdiction. These are 340, now 379.
79.
How do I have jurisdiction?
It is to be filed in the same court where the
This is not a recall
alleged
application.
perjury was made, my lord. My lord, as because the perjury, my lord, was made in the affidavit of opposition in a writ petition which was heard by my lord.
Oh, an order
As
was
such.
passed on the basis of that.
Yes. My lord, I at the outset, my lord, I pray for some time. I'm being led by Mr. Kollol Basu. Today, my lord, he's under some difficulty, my lord. As such, my lord.
On the prayer of the petitioner, let the matter stand adjourned for a week.
Yes, my lord.
Let the matter stand
Deeply obliged,
adjourned till February 21, 2025.
Deeply obliged, my lord.
You are appearing for the sake. Give a copy to them.
They have served, sir.
Mr. Punjabi are not directing the affidavit in opposition because in a 340 we have to be prima facie convinced first. So there is no scope of affidavit. 10, yes. Now the motions. You paid for time on the last occasion. Yes. Learned counsel for the petitioner submits that the petitioners do not want to proceed with the matter. Full stop. Accordingly, CO 3678 of 2024 is dismissed for non-prosecution without any orders to cause. Full stop. The written instructions filed in court today by learned counsel for the petitioners be kept on record. Thank you. Thank you. Next. Yes, what is the matter? Yes, Mr. Das, what is the matter? There is no caveat. Well,
the expertise degree was passed.
Mhm.
Put for declaration and permanent injunction, my lord. Thereafter, my lord, whatever.
Expertise what? Preliminary degree or final?
No, my lord.
Or declaration permanent?
Declaration.
Achha.
Then, my lord, what happened, my lord? So,
Stood
my lord, in the
decreed?
first, my lord, we appeared. Subsequently, my lord, due to miscommunication, we did not appear, my lord. Expertise order was, degree was passed. Thereafter, I filed an order 47, my lord. That
Order?
was rejected. Order 47. My lord.
Section 40.
Section 40. I'm sorry, my lord.
Rejected, then?
Rejected. Then, my lord, against that, I have come, my lord. So, my lord, it is late, my lord. Kindly come to impugn order, my lord.
What is the ground in your section 47?
Well, if this is my lord, there is so many co-sharer, my lord, in the property, my lord, and that was not implemented. That's why, my lord, I have filed this.
How was it dealt with by the court?
Rejected that in this stage, my lord, at the my lord, the execution stage, the learned judge
Cannot go behind the degree.
that is but my lord, we are staying there for long, my lord. This is the property of one Ismail Sheikh, my lord, and we are the he has 3 wives. So we are the heirs of my lord, one of the wife, my lord, and they are
Understood,
staying.
but this is not a ground for section 47. Court is right. It is a ground of non-joiner of necessary parties. So for that appeal lies. Sorry, no interference, Mr. Das. Wrong court. Wrong matter. Anyway, the present revisional application has been preferred by the judgment debtor in a suit for declaration and permanent injunction. Full stop. Next para. After suffering the decree, comma, the judgment debtors stroke revisionist petitioners took out an application under section 47 of the Code of Civil Procedure on the ground that all the co-sharers of the property had not been implemented in the suit. Full stop. The said revisional application has been dismissed by the impugned order on the ground that the ground raised therein is beyond the scope of the executing court to consider under section 47, comma, which relates to execution, comma, satisfaction or discharge of the decree. Full stop. Next para. This court is in complete agreement with the reasons assigned by the learned executing court, inasmuch as the question of non-joinder of necessary parties is at best a legal ground which could have been canvassed by the judgment debtors by way of a proper appeal preferred against the parent decree. Full stop. However, comma, it is trite law, TRITE, trite law that the executing court cannot go behind the decree. Full stop. Accordingly, comma, I find no infirmity in the impugned order and or jurisdictional error. Full stop. Hence, CO 3688 of 2024 is dismissed, thereby affirming the impugned order bearing order number 48 dated August 26, 2019, passed by the learned civil judge, Junior Division, 3rd Court at Krishnanagar, District Noida, in miscellaneous case number 49 of 2018, arising out of, what is the execution case? Arising out of title suit number 28 of 2014. No orders to call. Sorry, Mr. Das. Next.
I am appealing for the petition.
Yes, Mr. Rai, what is the matter?
PMT is the petition before lordship.
No caveat.
No caveat, my lord.
PMT, right.
PMT.
On what ground? Both courts?
No, my lord. Here the application for injunction has been allowed by granting ad interim order of injunction. That is subject of challenge before your lordship.
What is the ground of challenge?
Challenge is if your lordship can consider the order, the interim order which was passed, that is order dated 24/6/2024.
Yes.
Where your lordship find there is nothing on that passing an order of injunction in respect of a property which is subject of preemption. If your lordship can consider there is no, only I could not understand there is a direction for not to transfer or create third party interest, but granting status quo practically curtail my enjoyment over the property in question. And what is the immediate threat for passing an ex parte ad interim order of injunction?
You are the preempt.
I am the preemptive.
The proposed preemptive. I mean, but why curtailment of your rights? You cannot transfer the property. If you transfer, there will be multiplicity.
I could have understood that there is. Yeah, your lordship kindly consider. Positive number direct to status quo in connection with the case scheduled properties. Practically, status quo is for every aspect.
What aspect are you harping on?
I want to.
Status quo means whatever there is, you are there in the property, so you carry on.
I cannot do my. It is a commercial plot. It is. I want to exploit it commercially. I may not transfer the property. Under the preemption proceedings, I cannot ask for any improvement, cost for improvement. That is barred. I cannot ask for the same. For that reason, my lord, where is the provision? I put this question once.
You want to carry on business over there.
Yes.
So that does not violate the status quo. How does it?
Subject to question, my lord.
Status quo means whatever condition there is.
Yes, that is
the property. The status quo regarding the property.
Property. That is now it is as vacant. It is guarded by wall.
So you cannot transfer the property.
I transfer. I am admitting people. I am conceding to that. I cannot transfer because it will create.
I'll dismiss your application. I'll say that this status quo shall be interpreted in this manner, and you
only is restricted to my.
No fettered in carrying on business there.
Yes.
The present revisional application has been filed against an order granting blanket status quo order against the preemptees stroke petitioners. Whose learned counsel for the petitioners argues that a blanket status quo order would curtail the enjoyment of the petitioners in respect of the suit property of which they are in occupation. Next para. It is submitted that the petitioners cannot commercially exploit the property even if they want to, although there is no intention on the part of the petitioners to.
Third party.
Page has been stuck. Of the petitioners to transfer or create any third party interest in respect of the subject property. Next para. It is evident, in any manner from the prayers made in the injunction application on the basis of which the interim order has been passed, as well as the tenor of the order, that status quo has been directed to be maintained in respect of the property, meaning thereby that the current enjoyment and or possession of the property by the petitioners and or any sort of user of the property by the petitioners has not been restricted. What has been restricted is the creation of third-party interest and or encumbering the suit property or transferring the same in any manner in favor of third parties. Full stop. Hence, comma, in view, in the light of the above observations, comma, I do not find any scope of interference with the impugned order. Full stop. Accordingly, CO number 3699 of 2024 is disposed of without interfering with the impugned order in the light of the above observations. No address to court. Done. Next. Yes. আচ্ছা এইগুলো মোশন এগুলো হলে শেষ তো না আমাদের মোশন যেগুলো অ্যাসাইন হয়েছিল 100টা শেষ হতো Yes.
So I'm appearing for the opposite party.
Your Lordship, I'm appearing on behalf of the
Petitioner.
petitioner.
Yes. What is the matter?
Your Lordship,
You are for the caveator or all the opposite parties?
No, well, there is only a single.
there's only single
Right. Yes, ma'am.
respondent, Your Lordship.
Move on. Take your seat, please. Yes. Yes. Yes, please.
Your Lordship, this is a matter where the right or where my written statement has not been allowed
one
to place
thing-
on record. Yes, Your Lordship.
One
This is
thing
a non-commercial suit.
in the cause title,
Yes, Your Lordship.
when you write petitioner stroke defendant, the first caption will be the capacity in the court, defendant stroke petitioner. So what he was in the court below, then please keep this in your mind when you file division
Oblige, Your Lordship. I'll take care.
and
Future.
make a whispering campaign to all your friends on
I
this.
will take care
We
that
are
in
seeing
future.
this mistake being repeated.
Yes,
It's
Your
defendant petitioner. If it's against an appeal, defendant appellant petitioner. It comes
You're
from below. Anyway, what is the matter? Yes. Non-commercial suit. What is
Yes,
the
Your
suit? for?
Lordship, non-commercial suit, very small point, Your Lordship. The point is that my written statement was not kept on record. I'll just give you the background, Your Lordship.
You overshot the time. The still
Yes, Your Lordship, definitely. But the point over here is that the copy of the plaint was never served to me. I have filed 2 applications seeking the copy of the plaint. However, the same was not
Let
served
us
to
come
me.
to order it
Order
will 1 and 10. Yes. We shall not be later than 90 days from the date of service of summons.
Yes,
Summons was served on you
Yes, Your Lordship.
without plaint.
Yes, Your Lordship. These summons was, Your Lordship, if I may put it like this, even the summons was never served to us. Order 39 Rule 1 and 2 application was served to us. So I presented, Your Lordship, all I'm seeking is I'll give you few dates, Your Lordship, if Your Lordship can note down those dates, Your Lordship.
Yes.
It will just become easier, Your Lordship.
Yes.
So, Your Lordship, the suit was filed.
Suit is for declaration
Yes,
injunction.
it was a title suit, Your Lordship. On 28th August 2020, the suit was filed, Your Lordship. 28 August
8 28
Yes,
28 8 20.
Yes, Your
Yes,
Lordship.
next.
20 during the COVID period, Your Lordship.
Yes.
28th August 2020, the suit was filed, Your Lordship,
Yes, yes,
and
what next?
summons was issued. It was never served to us, Your Lordship. The matter was taken up. The matter was first time it was taken on 10th September 2020, and I did not appear. Your Lordship, on
You were
that.
served with an injunction application when?
Yes, Your Lordship. On 10th September, the plaintiff filed 3912 application, which was duly served to us, Your Lordship. If Your Lordship can come to page number 23.
When was it served?
Yes, Your Lordship. It was served to us. Yes, I will. I'll just.
Anyway, when did you next appear?
Your Lordship, for the first time, I appeared on, Your Lordship, 20th January 2021.
Right.
Yes, Your Lordship. I was marked, I was proceeded ex parte. Because that on 3912, it was very clearly written that I had to make appearance on 19th of November 2020. I did not mark my appearance, so I was proceeded ex parte. The 3912 application was duly served on me. When I appeared on 21st January 2021, I filed 2 applications, Your Lordship. The first,
21st January or 20th January?
sorry, 20th January.
Yes.
Yes,
You
Your
filed 2
Lordship.
applications?
I stand corrected, Your Lordship. 20th January 2021.
1 second, ma'am.
Yes.
The date was fixed for ex parte hearing of the suit itself or the injunction?
It was for the injunction hearing. Yes, Your Lordship. Because on the first day, the injunction application was not allowed.
Wait. What were the 2 applications?
So I filed 2 applications. The first application was to serve me the copy of the plaint.
And second?
And the second application was, Your Lordship, to give me an opportunity to file written objections.
Written objection to the injunction?
to the injunction and to the written statement as well once the copy is served to us. Your Lordship, what has happened that both the applications were rejected because I was preceded ex parte, because I did not file any applications for setting aside the ex parte.
Let us come to the impugn order.
Yes, Your Lordship, let's come to the impugn order. It is on page number,
The certified
last
copy.
certified
Yes.
copy. If I may, Your Lordship,
Please.
Written statement filed, but no petition has been filed for condonation of delay. Therefore, there is scope for application of discretionary power as per clarification of Honorable Apex Court in 2022 SCC 708 between Desh Raj versus Balkrishan through proposed legal representative MS Rohini, where Honorable Apex Court held further as regard the timeline for filing of written statement in a non-commercial dispute, held the unamended on Order 8 Rule 1 of the CPC continues to be directory and does not do away with the inherent discretion of courts to condone certain delays. Therefore, the written statement filed on 19th December 2020 filed
Yes,
by
sir.
the...
What is this?
Yes, Your Lordship.
What is this? Could this order, can you support this order?
Comes to page 59.
59 years.
This is order number 4. The trial court. Handwritten manner and the type copy has also.
Yes, yes. No difficulty.
20 files Hazira along with postal receipt and track report.
You take your seat, ma'am.
Summons and notice are duly served. Kindly note, my lord. They're coming with a ground that they had not received the plaint. But if I take your lordships to the records, Lord, and they had made their appearance duly, they had not raised an objection in any way in written form up to a certain point. Then they come and make out this. They have not challenged this order.
No, before 20th of January 21, they entered appearance.
No, your lord.
So that is the first time they entered appearance.
They came in on 20th of January 2021. On that date, the hearing of the petition of injunction was fixed ex parte. Allegedly, they are filing 2 applications which are not there with the CO. So I don't know what are the contents of those applications, Manoj.
But even then, there is a scope of filing any section 5. There cannot be any section 5 in connection with the court has the discretion to condone the delay. The court could have just directed them to file an application explaining the delay.
With the written statement, before that, your lordship will find that in multiple cases,
yes,
previously this had already been fixed for ex parte. So they were given opportunity. It was removed from the preemptory board and then it came back to the regular hearing board.
Why? If they did not appear, why did it come back at all?
After that, because they had changed their advocate on some grounds that the previous advocates were sick, and that order is at 11/4/2022. Your lordship, that the order is at 67/68. 67 of the application. Your lordship will come. And before that, if I may trouble your lordship, kindly comes to page 60 on application.
60.
Page 60, your lordship.
Yes.
Their application?
Yes.
And it is as per their
they had already
filed on 2021, 20th January, but this is dated 2020 at the bottom, my lord. This is
Could be a typographical error. Very.
I'm not going into the
Yes,
because the stamp over is there.
Obviously.
The stamp is there.
Kindly see, there is not an iota of a whisper saying that I have not received the plaint.
Your lordship, if your lordship can come to page 61.
You'll have your reply. Yes.
They are specifically saying that I need time because documents and so are not ready for with me for filing the written objection to the injunction application. The first time a person appears, your lordship, if they have not got the plaint, there will be one iota of a whisper and the order records that they had received the summons. They are not challenged. They have never challenged that order. And your lordship, no, the body down. And thereafter, your lordship, what I need to bring to your lordship's notice, your lordship, I have, as per instructions, my lord, I have got 2 applications which they have filed in the trial court on 13th of November 2024, exactly on these grounds of setting aside the ex parte and condonation of delay. So what remains of this CO if they have gone back before the trial court and asking for the same release, my lord? Kindly have a look. And there is not an iota of a whisper that this civil revision is pending.
Setting aside of the order impugned here.
Yes, order impugned.
Now they have overshot that time of the outer limit of
Yes. They have overshot. My lord, there is no scope of that.
30 plus 90 also 120.
That they have overshot. But even then, my lord, being fair, my lord, I understand there's some liberal approach may be taken, but look at their conduct. What they're trying to establish is that I have not got a written statement copy, the plain's copy. The court clearly records that summons was served, duly served. And your lordship will kindly see that they have affixed their, whatever they're saying as the notice, which what they have come at page 23 to court. It clearly records by the belief that it was received by them. Kindly comes to my lord, page 24 of the application. No objection was raised. Except by making out an excuse.
Your lordship, if I may just assist this court now.
No, we'll hear you. I'll hear you before disposing of the matter.
Because my learned friend is only giving me the half record. I mean,
You give the rest of the half when you speak. Please take your seat, ma'am. Please take your seat.
Yes,
First, you
yes,
take your seat. Is there anything behind you? Yes.
Yes.
Take your seat. Let him finish, then you will give your side of the picture.
Even with the order 39, rule 1 and 2 application, your lordship, they took time and time again for filing written objection. Then ultimately it was an oral argument because they did not file the written objection. So this is not a repeated ploy I find just for dilatory tactics.
The injunction application is still pending.
Injunction application has been disposed of, your lordship. It's a status quo. It was disposed of, your lordship, by an order dated.
No, we cannot reopen that in any event.
Well, that is not required as well.
No.
That, this ground that they're taking that I was.
So
not
they had filed the written statement on 19th of December 2022. They had filed the written statement.
Yes.
That is recorded in the present impugned order. So they had filed it long back. So, so if the summons was served, but that was also, but as per 2022, which has been cited, court still has discretion probably after this non-commercial suit.
Yes. Court has a discretion, but the conduct of
Their conduct is very bad.
Conduct is very bad.
So let them compensate you by costs.
That is, my lord, I have a strong objection because basically after at this juncture,
Yes.
your lordship can understand what
It is not a case that the written statement has not been filed. It has been filed. No, the court rejects it only on the ground that court was to consider what is the
issue is only one.
because the proviso does not contemplate any application being.
I agree, your lordship. Whatever is followed.
Court can insist upon an application.
My lord,
that opportunity ought to have been given.
Court can insist. The second thing is that where is the perversity in the order, your lordship? It's a special statute. Can 151 be resorted to? That is my question to.
151 can be resorted to.
Overriding Section 5 of the Limitation Act.
No, Section 5 does not apply.
Well, that is.
Section 5 is not applicable to a written statement. That is the basic premise we cannot forget. Section 5 applicable to a suit, maybe to an application, to an appeal, not to Section 5.
No condonation of delay application.
Yes. So therefore, Section 5, there is no scope of Section 5. If we expand the time, that will be under 148 basically.
That is
basically 148 read with 151 maybe. And there is no specific bar in the sense that yes, proviso provides a specific bar, but that has been diluted by Supreme Court.
My point is something different. My
Yes.
point is, can somebody take a ground of this nature where on record it is found that it was actually served on them? So they are now coming and questioning the bona fide of the learned trial court. And they have not challenged that particular order by which it is recorded that the summons was duly served. So now, therefore, by implication, my lord, then that order also goes out of the window. At this juncture, without any specific prayer, that there was an error in that order.
No, even if we proceed on that premise, that summons were served and they filed their written statement on 19th of December 2022. And by very filing of the written statement, it is made obvious by them that they had a copy of the print.
No, that how they have got, they have explained, your lordship. That is in a particular writ petition, which was.
Oh, it was annexed there.
We had annexed the plaint. They are saying that we got the plaint by virtue of that writ petition at a delayed date.
So let us condone the delay and impose costs on them, and so that, or I can relegate it to the trial court. But our observations
have been already preferred. My submission before your lordship.
No, this application automatically goes.
So they are basically forum.
These are not similar reliefs.
Well, these are similar reliefs. Kindly look at the prayers.
Maybe similar, but
one
is 151 review, one is review. One can file a review and an appeal at the same stage.
That your lordship, I won't.
Yes, how do you explain these
Yes,
irregularities?
I will
Your
just
conduct is very bad.
Your
Why
lordship,
should it be
I will
condoned at
try-
all?
On basis of record only, I'll show that this is not the wrong conduct,
Show
your
us.
lordship. Your lordship can come to page number 23, your lordship. It's a very simple, Your Lordship, when we got this matter, I seen the record and then only I have taken these points, Your Lordship.
Yes.
If Your Lordship can come to page number 23.
23, yes.
Yes, Your Lordship. So this is the summons which we have received, Your Lordship. Now, Your Lordship, it says, whereas the above named has been application on the court. Now, Your Lordship, we have to come appear on 19th day of November, Your Lordship. On 19th November 2020. Now, Your Lordship, if Your Lordship can come to the second page, page number 24. It records this, and on page number 25 is the application of 39(1) and 2. So, Your Lordship, they filed an application on 39(1) and 2 on, I'll tell you the date, Your Lordship. On 28th.
1 minute, there's an
Yes, Your
endorsement of the bailiff. Let us see that. Page
Yes,
20.
Your Lordship.
Page 24, Your Lordship.
Yes,
Kindly
Your
see
We are looking at that. The brother was present on behalf of the UP. He read the contents of the notice and the petition. Petition means the injunction petition.
Yes, Your Lordship. That is what I'm trying to explain. We never received the plain copy. And Your Lordship, if Your Lordship can come
No,
to
there's a
page.
presumption correctness attached to the order of the court otherwise. Official and judicial act.
Yes, Your Lordship. And Your Lordship, I'll just show one more page number, Your Lordship. That is page number 60.
60.
60, Your Lordship. So when we entered appearance for the first time, Your Lordship, on 20th of January 2021, I filed 2 applications. One is page number 60, where I'm saying that the written objection needs to be filed. And then the second page is the same, another application, where I'm saying that serve me the copy of the plaint. On the first date itself, I have filed this application. Your Lordship, the same application has been filed thrice. I will show you by recording.
Very well. And did you file any application when you filed the written statement on that December?
Your Lordship, we filed the written statement from the writ petition copy because my advocate.
Where was that explained? That
Yes, Your Lordship. I will just.
in the written statement itself, or
No, we have not explained that anywhere.
so? How do they get to know that that was the reason? You have stated in the revisional application.
Yes, Your Lordship. If Your Lordship can come to, because we were served the writ petition copy, from that we got the hold of, because Your Lordship, I'll just tell you 2 more instances. Your Lordship, we did file another application. We gave it to the plaintiff. They refused to give me the copy of the plaint. Your Lordship, I'm not getting into that. All I'm saying is that from the writ petition, I got the plaint copy and I immediately filed my written statement.
You have annexed that writ petition here also.
Yes, Your Lordship. I have annexed it. Yes, Your Lordship.
Yes.
Annexed.
Page 86, my lord.
Right.
I have not annexed all the annexures, Your Lordship, but in that written statement.
Is your written statement a part of the?
No, Your Lordship. This is not does not form the part. But definitely I can bring it on record by way of. Your Lordship, I'm seeing over here that the plaint copy was never served to me, Your Lordship. And Your Lordship, at 3 instances, I have filed this application for supplying me the copy of the plaint, Your Lordship. The second instance was, Your Lordship, again, which was recorded in the order also, Your Lordship. On 21st December 2021, Your Lordship.
Yes, there is some doubt as to whether the plaint was.
Fine print, Your Lordship. Kindly comes to page 59.
Page 24, it says, the bailiff says notice and petition. 59.
Yes, it is the order of the court, what they are harking on and what is the actual
59,
order.
yes. 59.
How the plaint has been served. Plaintiff files Hazira along with postal receipt and track report. The summons was by postal receipt and track report, which is there with the record. What they are saying, that is the bailiff's service of the order 39.
But if the service through court was
if the service, my submission.
If that was accompanied by the injunction petition only, there is a presumption that your other service is also same. Track report only shows that something. The track report is the court does not weigh or ascertain the cost of the weight of the.
I agree, my lord. Where has this been challenged?
Your Lordship,
It not be challenged.
The summons.
It not be
My
challenged.
lord knows there are both the practices that there. One goes to the party, one goes to the court.
Yes, if there is if the one which you filed through the court that does not carry a copy of the plaint but only an injunction application, it is all the more possible that you send the other copy.
That this particular recording is erroneous.
Let's assume without admitting even. No, I am saying, Your Lordship, let's assume that it was served to us. But Your Lordship, on the. No, all I'm saying is.
Kindly.
She's constantly interfering. That is the difficulty.
I apologize for that, Your Lordship.
Kindly comes to page 63, the order of the court rejecting their first two applications.
Yes.
My lord, as you feel from your lordships, my lord, just now that there has to be a presumption regarding the judicial observation. Why was these two applications rejected? Have they challenged this rejection till date? They are saying that I have made multiple applications. It keeps on getting rejected. Where have they come before your lordships previously? They would have come previously if something erroneous was there. They have not challenged the application order at
No, the
63.
court rejects. They consistently say in their applications that they have not got a copy of the plaint. On that ground, they repeat their prayer that let it be taken off from the ex parte board. But the court just rejects it in a one line, two petitions, along with two petitions, but the suit has already been fixed ex parte against defendant, therefore rejected.
With the ground that their previous advocate was sick, then also it was taken off from the peremptory hearing once before. I will tell your lordship the date.
No, but this page 61 we cannot ignore that application is there, but the court disposes it off by saying that
Page 63.
page 62, 63 also that's a typed copy. Court only says that it's the suit has already been fixed ex parte against defendant.
Yes, it's not a very speaking order, my lord. That I have to.
Very.
Non-speaking order.
No, my lord.
At least has to deal with their allegation that whether the plaint was served. Look into the bailiff's report. Bailiff report says petition.
My lord, now kindly comes to page 64 because we don't have the. I don't know, my lord, what was there in the. Opportunity was given to them to file a proper petition. In page 64. Lordship finds.
Page 64, plaintiff files Hajira, defendant files fresh wakalatnama along with the petition.
Praying for permitting him to contest in the suit on the ground stated therein. Fixed 21/12/2021 for proper petition.
What is proper petition?
So they can only explain what proper petition they have to file.
By proper petition, they meant, Your Lordship, was to file an application so that the ex parte is set aside.
65. Next order. Defendant files two petitions for withdrawing the suit from ex parte board on the ground stated therein. Copy served. Fixed so and so date for hearing petition.
Court repeatedly did the same thing. Not dealt with their allegation that they are not served with a copy of the plaint. No.
But they have not.
There's a presumption they did not get a copy of the plaint. Heard learned counsel for the parties. First up, the present revision has been preferred. The present application under Article 227 of the Constitution of India has been preferred against an order whereby the petitioner's application, the petitioner's written statement has been refused to be accepted by the learned trial judge and the suit fixed for ex parte hearing. First up, next para, learned counsel for the petitioner argues that no copy of the plaint was served along with the summons on the defendant stroke petitioners at any point of time. Defendant stroke petitioner at any point of time. First up, it is contended that despite the petitioner having filed repeated applications before the trial court, indicating that no copy of the plaint had been served, but only the injunction application had been served on the defendant, the court brushed aside such contention and merely reiterated that the matter has already been fixed.
Seek your lordship's indulgence, my lord. I'm very sorry to interrupt.
On the ex parte board.
Sorry to interrupt.
Yes.
Kindly comes once. This is why I was trying to figure out.
To page.
Kindly comes to my lord, page 70. The order starts at page 70. Page 70. There's the injunction order. And
yes,
comes there in my lord at page 73.
Yes.
Now, my lord, kindly comes when they were arguing the injunction order. My lord, in the middle of the page, after the first paragraph ends.
Yes.
Learned advocate for the defendant, your lordship has found, my lord. Learned advocate of the defendant, on the other hand, has submitted that the plaintiff has filed the suit for declaration and not for permanent injunction. He has submitted that in the prayer part of the injunction application, the plaintiff has prayed for relief, which he has not mentioned in the prayer part of the plaint. How would they come to know of this at this day?
Is the injunction application annexed here?
Injunction application is annexed there.
Yes.
But
Here.
Yes.
Let us see that.
They are saying if they are.
You might have quoted your prayer in the injunction application. Let us come to that.
How are knowing the contents of.
I'll tell you how they are knowing. Let us come to the injunction. I'll immediately tell you how they are knowing.
Injunction application is from page 25, your lordship.
25.
Specifically mark that point. That's what we are searching around for, my lord.
Please come to paragraph 17 of your injunction application.
My lord.
That is how they came to know.
But the plain sprayers are not produced therein.
That the plaintiff is therefore constrained to file this suit
Your
against the defendant for declaration that the defendant has no right. You have set out your reliefs.
My lord, that is an assumption your lordship is taking out against me. My lord,
No, no, it's very clear. That is always done in an injunction application. Everybody does that.
Your lordship, normally when we draft, normally the first paragraph comes with the prayers of the plain. That so and so and
even if not the first paragraph.
whatever they
Yes,
have got.
yes. So from that one can very well say, argue
My lord,
that the prayer part of the injunction.
Specific submission. It's a specific submission, my lord, at page 73.
Could be derived from your application. I'll deal with that also. I have to because you have argued.
Kindly will record my submissions, my lord.
I'll have to deal with your submission, not only record. The next paragraph.
It is considered that despite the petitioner having filed repeated applications before the trial court indicating that
Brushed aside bole
contention and merely reiterated that the matter has already fixed the expertise.
Yes. Push up next para. It is further argued that the defendant stroke petitioner subsequently got to have a copy of the plaint which was annexed to a writ petition filed in this court and accordingly filed her or his Kaiser is his written statement on December 19, 2022. Full stop, next para. However, comma, by the impugned order, comma, the learned trial judge refused to accept the written statement by completely overlooking the fact that the rigors of Order 8 Rule 1 of the Code of Civil Procedure were not applicable since no copies of the plaint had been served at any point of time along with the summons on the defendant, comma, thus rendering the service of summons incomplete. Push up next para. Learned counsel appearing for the opposite party argues that it will be evident from the injunction order passed by the learned trial judge on August 22, 2022 that learned counsel for the defendant in the court below had clearly submitted that in the prayer part of the injunction application, the plaintiff has prayed for relief, which he has not mentioned in the prayer part of the plaint. Accordingly, comma, it is submitted that it can very easily be, hence, comma, it is submitted that it is obvious that the defendant, comma, even at that juncture, comma, that is on August 22, 2022, comma, had a copy of the plaint containing its prayers. Push up next para. Learned counsel for the plaintiff opposite party further submits that the conduct of the defendant stroke petitioner is deplorable. Pushed up, the petitioner has filed numerous applications and several times the suit was taken off OWF, the ex parte board, on different grounds taken by the petitioner. Pushed up, next para. Learned counsel for the opposite party further places reliance on the order of the learned trial judge.
Page 59.
59, thank you very much. Dated November 19, 2020, where it was categorically recorded that the track report shows that summons and notice were duly served on the defendant. Full stop. Thus, comma, presumption of correctness has to be attached to the said order, comma, since it is a judicial act coming within the purview of section 100. Now, what is the corresponding? Since it comes within the purview of judicial act. Full stop. Next para. In the absence of any explanation as to the delay in filing the written statement thereafter, comma, it is contended that the learned trial judge was justified in refusing to accept the written statement and fix the suit for ex parte hearing. Pushed up, next para. Learned counsel for the opposite party further adds that the order dated November 19, 2020 was based on a bailiff's report. However, comma, it has to be kept in mind that the bailiff's report pertained to the summons served through court, whereas service had been directed to be effected both ways, and the track report clearly indicated that summons along with the plaint was duly served by postal service. To the next para. Upon hearing learned counsel, I find that certain doubts arise as to whether the summons were properly served on the defendant stroke petitioner. Push up next para. From the bailiff's report annexed at pages 23 and 24 of the present application, I find that the bailiff observed that the defendant stroke present petitioner read the contents of the notice and petition and accepted copy of the same on granting his signature above, the Dublin notary. Full stop. Next para. Hence, even from the bailiff's report, it transpires that it was a notice and a petition which had been served on the defendant, creating an impression that it was the injunction application, as contended by the defendant, and not the plaint which was served on the defendant. Pushed up next para. Learned counsel for the plaintiff opposite party has harped on the order dated November 19, 2020. Pushed up, the said order records that the track report showed that summons and notice were duly served. Pushed up, however, the postal receipt and the track report served by way of alternative service as contemplated under Order 5, Rule 9 of the Code of Civil Procedure cannot be a conclusive proof, particular proof of service of the plaint, particularly in the context of the present circumstances. Pushed up, since the service of summons sought to be effected through court is doubtful, as the bailiff's report states that only a petition was served along with the summons and not the plaint, there cannot be any reason to deem the alternative service effected directly through postal modes to be sacrosanct. First up, the malady which vitiated the service of summons through court might very well have afflicted the alternative service as well. First up, next para. Thus, there is some doubt as to whether the defendant had got a copy of the plaint prior to getting the copy of the writ petition where the said copy was annexed. Pushed up, next para. Thus, I find that there was sufficient reason for the written statement to be filed late by the defendant, only after having a copy of the plaint as annexed to the writ petition concerned. Pushed up, since the written statement had been filed on December 19, 2022, the learned trial judge, after 2 years thereafter, almost 2 years thereafter, could not have refused to accept the same merely on the ground that no petition has been filed for condonation of delay. Pushed up, there is no applicability of Section 5 of the Limitation Act to a written statement. Pushed up, the court always has the inherent discretion under sections 148 read with section 151 of the Code of Civil Procedure to enlarge the time for filing written statement. Pushed up, in the present case, in view of sufficient doubt having been created as to the defendant having received the copy of the plaint late, it was for the learned trial judge to take a liberal approach, in line with the judgment in Deshraj versus Balkishan, reported at 2020, Volume 2, SCC 708, which was cited before the learned trial judge, and to accept the written statement and take the suit off the ex parte board. First up, in such view of the matter, this court is of the opinion that the impugned order suffers from such jurisdictional error. First up, accordingly, CO number
3707.
Thank you. C707 of 2024 is allowed on contest, thereby setting aside the impugned order dated impugned order bearing order number 27 dated August 29, 2024, and directing the learned trial judge to accept the written statement filed by the defendant stroke revisionist petitioner on December 19, 2022. First of the suit be taken off from the ex parte hearing board. First of next para. In view of the delay occasioned in disposal of the suit, comma, the learned trial judge is requested to endeavor to dispose of the suit as expeditiously as the business of the said court permits. No rest to cost.
Subject to your lordship's indulgence, my lord.
Yes.
Presumption on the General Clauses Act lies in my favor, my lord. They have not pleaded that issue.
Rebutted by that bailiff's report.
So that is only for the order 39, but the correctness of that particular order.
No, rebutted by that bailiff report because you are right. You have a point there, but the bailiff report itself vitiates that presumption because the bailiff report says only petition was served.
Substitute service.
Yes.
But that they had not received the plaint even through the substitute service. There is no specific pleading as to it. And
there was substituted service also.
Yes, your lordship. That's what the order records.
Substitute service.
The same thing.
Substituted service.
Yes, spec report of the postal receipt which went through the party.
That is not substituted service.
Sorry, that's
alternative mode of
alternative mode of service. My lord, but the presumption on the General Clauses Act rises in
file an SLP. Next one. Yes.
Oblige, your lordship.
Subject to your lordship's correction.
Your lordship, I am filing the
affidavit of service filed to be kept on record. Yes, next.
Gratefully.
Thank you.
Oblige.
Next. Item 14.
My lord, in item 14, I am appearing for the petitioner defendant, my lord.
Yes.
My lord, in this matter, my lord, I have challenged the order passed by the first appellate court confirming the order of injunction till disposal of the suit. My lord, my only ground is that the learned appellate court usurped the jurisdiction of the learned trial court because the appeal was preferred from an order refusing an ad interim ex parte order of stay. So instead of, my lord, relegating the matter to the learned trial court to dispose of the matter
refusing ex parte order of stay or injunction? Injunction was
injunction, my lord. It was an ex parte order of injunction was prayed
no,
for. That was
the appeal court disposed of the appeal or in an ad interim
stage? Disposed of the appeal, but by directing that the injunction order will continue till disposal of the suit. If my lord kindly takes the first order refusing the ex parte ad interim order of stay, that is at page 23, my lord.
The injunction application is still pending in the trial court.
No, my lord, because now that the appeal court has disposed of and has directed the injunction to continue till disposal of the suit, it virtually makes the injunction application.
No, the injunction has been formally disposed of in the trial court.
No, my lord. But I believe once this appeal court order is shown before the learned trial court,
serve a copy. I'll grant a stay subject to the injunction application operating till disposal of the injunction application.
Yes, my lord. Yes, my lord. That is all that I am praying for.
The limited question on which the present revisional application has been filed is whether the learned appellate judge was justified in granting injunction till disposal of the suit.
My lord, that my lord will find at the last page of
while sitting in appeal over an ad interim order of refusal of injunction granted by the learned trial judge. Full stop. There is the revisional application is required to be heard on such question. Full stop. The petitioner shall accordingly serve a copy of the present revisional application on the plaintiff opposite party number 1, indicating that the revisional application shall be listed for hearing before the appropriate bench having determination in the monthly list of March 2025, subject to the convenience of the said bench. Full stop. Next para. There shall be stay of operation of the impugned order to the extent that the impugned order shall be deemed to operate till disposal of the injunction application pending before the trial court and not till the suit. Full stop. The above ad interim order shall operate till disposal of the present revisional application.
I'm extremely grateful to my lord.
Yes. Yes, Mr. Chatterjee.
I am for the opposite party.
Oh, yeah.
And I think for the petitioner. You chose this.
Yes. Challenge against?
Challenge against an order whereby, my lord, an application for injunction in form of a mandatory nature has been allowed by the appeal court. Now, my lord, what has happened, my lord? There were two suits.
Yes.
My lord, one suit filed by the petitioner herein as plaintiff, my lord, wherein he sought for a, my lord, declaration that the defendants, my lord, are tenants in respect of the godown only. And my lord, there was another suit filed by the tenant, who is the present opposite party and plaintiff in the other suit, praying for a declaration that, Lord, he is not only the tenant of the godown, but the entire ground floor, which comprises of a garage portion lying in front of the godown. Now, my lord, all this plaint started from, my lord, the basis of the plaint which was filed by my
Suits are being heard analogously?
Yes, analogous.
Right. Then?
Now, my lord, a decree was passed in my favor saying that yes,
only go down.
Only go down, no use of the garage space.
And their suit was naturally dismissed also.
Naturally dismissed.
Then title appeal against
Two
that.
appeals were preferred.
Two appeals by them, yes.
My lord, similar nature of application was filed in two appeals. My lord, one, my lord, is this civil revisional application, and other was, my lord, I must apprise my lord, another revision has been filed but was assigned to, my lord, different bench in the cluster of 100 matters. My lord, we have prayed before that bench for release. And my lord,
Cannot, if it is assigned, the bench cannot release.
Her lordship has released because we have prayed because one matter is pending before my lord, and since my lord,
I am also releasing so that it is assigned to a third bench.
Her lordship has already done that, my lord. That is, my lord, we have prayed for.
Anyway, what has been done by this?
My lord, what happened, my lord, in the appeal court, my lord, they took out an application that we should not be allowed to put padlock, my lord, in the entrance to have an so that they can use the garage, go down space. Now, my lord, that was allowed by the impugned order.
Go down, they have a right in any event.
Yes, go down, they have a right.
So how can you put a padlock?
Yes, there is the problem. My lord, the impugned order, my lord, doesn't say, my lord, in our, my lord, local inspection which was held in the trial court at the time of disposal of the suit, the commissioner has specifically awarded, my lord, the access to the godown is a different path. My lord, the garage has its own gate. My lord, garage will have a gate. My lord, I can have an access from a garage, and there is an other entrance in the property which leads to the godown also.
The local inspection report is annexed to the
No, my lord, it was illegible, so my lord, I'm carrying a copy.
So very well. So what has been granted?
My lord, kindly takes up the impugned order, my lord. My lord, I say, my lord, this order, only the ordering portion may I read for the time.
Yes, that.
The respondent is directed not to put any obstruction in the main gate. My lord,
Main gate.
I put the question, my lord, what is the main gate? Where is that finding? This is a main gate. My lord, by simplicity saying in an order, my lord, don't put a lock on the main gate. My lord, they are implicating the garage gate is the main gate. My lord, I am saying, my lord,
Mr. Chatterjee, unless they enter the main gate, how can they go to the godown also?
My lord, they have annexed certain photographs in the, my lord, their application before the learned trial court or the appeal court below.
That should have been annexed at least.
No, that is annexed. Page 135. That's part. 135. Has got 135?
Yes. 134 is the best of the lot.
135 is the lock they show.
134.
Okay.
Yes.
My lord's got 135.
The picture of the lock and all.
135 is, my lord will find two gates. My lord, in this picture, what they have relied upon.
But whether we don't know whether this is after coming through the main entrance.
No, my lord, this is
maybe
not
they have entered the main entrance and then taken the
photo. From outside the premises. This is not in dispute. This is from the road.
From the main road.
Main road. My lord, lying in front of the premises.
This Geo
is the garage. And my lord, side space. This is the main gate of the premises which leads to the, my lord, go down, my lord, which is behind the garage.
The garage also, you can also go to the godown through the garage.
Through garage as well as this passage.
But the godown cannot be used unless they come via this. What will be the godown? What purpose will be the godown used for? I mean,
Lord, they have
there must goods must go in and come out.
No, Lord, they have a passage. Godown has its own gate.
That can only permit some persons, 2 persons or 3 persons to enter.
Lord,
but
this
no
passage,
vehicle can go in. What do they store in the godown?
Lord, paper.
The paper has to come out and go in.
This is the passage, my lord. See this passage. This is no less than 6 feet. There's an entrance.
Can there be an ingress and egress
Yes,
to
yes,
that?
yes. That's the commissioner's report in the trial.
When a
court.
hand cart cannot go through that.
Milord, hand card, Milord, they do not.
How will they bring out the papers or whatever?
Milord, from
there must be bales of papers.
Milord, exactly, Milord. That's why, Milord, I need to read the judgment. Exactly, the basis was they were entering cars and placing in my garage space and creating a nuisance and claiming a right over the garage space. The trial court, by delivering the judgment, has discussed on this issue and said you cannot use that garage space by putting your vehicles there. You are restrained.
No, they will not put their vehicles there. That remains.
So, Milord, if they do not put their vehicles, Milord, they can
But
use
their vehicles can
passage.
go in and out. I mean, for the limited purpose of taking out the papers, we can restrict the time also if you want.
Now, Milord,
subject to hearing them.
This passage, since Milord, no local inspection in the appeal court was held, Milord, my instruction is this passage is more than 5 feet. Milord, a 5 feet, Milord, for a human being, Milord, is good enough space to carry on, Milord, load bearing, Milord, in head.
The paper bales are much larger.
Yes, Milord, those are carried in.
The human being will pass through, but the bale will be left behind.
Even, Milord, even if they enter the garage, they have to walk down to the godown. Milord, it's not that, Milord, they did not walk down, or Milord, they will just throw on the godown. They have to walk down.
Personally, they can, but how will the bales go in and come out? That is the difficulty. It cannot be used as a godown if they can't ply their vehicles, at least for the limited purpose of taking the goods in and bringing the goods out. And we can fix some time of the day.
Now, Milord, only one thing, Milord, if my cars are parked, Milord, and Milord, a vehicle comes in.
That will be difficult.
That would be this is what the Milord, in my responsible impugn order, Milord doesn't clarifies or Milord speaks of. Milord, I say, Milord, the impugn order, the reason given by the impugn order is not backed by reason. Milord, if Milord takes up the impugn order, it says settle. Milord, I'm reading, Milord, from Milord internal page 2. I'm not traveling, Milord, since time is short. Milord, it would take time to read the entire. Milord, page 2, last 2 paragraphs. I have perused the petition under section 151 of CPC filed by the appellant and the written objection thereto filed by the respondent. Perused the documents filed by the party. It transpires that the present applicant had filed title suit number such and such plaintiff in which the present respondent was defended. The present respondent had filed title suit number such and such plaintiff in which the present appellants were defendants. Both the suits were heard analogously. Milord, then again, Milord, the entire suit, Milord, extracts has been, Milord, given. Milord, there is no independent, Milord, recording of reason. Milord, facts are being recorded here. Now, Milord, leaving that paragraph, it is settled principle of law. Now, Milord, principle of law comes in. Milord, it is settled principle of that no landlord shall without just or sufficient cause cut off or withhold any amenities enjoyed by the tenant. The crucial consideration whether the act of the landlord respondent locking the door and thereby obstructing the tenant from entering the premises constitutes cutting off or withdrawing the amenity. To enjoy the right of tenancy in the godown, egress and egress of the appellant is required to go down through the main gate in the ground floor. The action of the landlord respondent of the putting.
Yes, the premise of the trial court was that there is a main gate and then there is these two gates. Show us the commissioner's report.
Yes.
Is there any diagram?
Lord, diagram, Lord, adjusted. So diagram has not been done, but Milord,
and the court's finding is also that respondent is required to be restrained from causing any sort of obstruction to the plaintiff's enjoyment of the tenancy right in respect of the tenanted godown.
Godown only. So, Milord, garage they have no right, and Milord, trial court doesn't, or the appeal court Milord doesn't find on which is the main gate. Milord, I say.
Let us see the commission. There is no main gate. There is no compound.
No.
Directly access from the road to those two.
3 entrances. Milord, one through the garage, one can enter. Milord, there is another Milord entrance which is 5 feet on the southern side, another entrance from the western side.
Have you got a copy of the commission?
Yeah. There is the copy, Milord.
You have an extra copy, give to Mr. Mukherjee.
Copy আছে commissioner's report যেটা trial court rely করেছে.
This is not illegible. Why didn't you annex it? They would have the advantage of going through this. This is very legible. You said it's not legible, that's why you have not annexed.
The inner pages
more legible than the other annexures. You have annexed this, Mr. Chatterjee.
এটা trial court.
Otherwise, you should give a copy to them.
এইটা eight, right? 71A.
71. Please come to page 5 of that.
My lord, yes.
Point number D. I find a main entrance gate just in front of the suit property
Yes.
facing
Now, my lord,
northern side.
now, my lord,
So there is a main gate.
kindly turns to my lord internal page 7. Or my lord, rather directly to internal page 8. My lord, found my lord the 8. My lord, first paragraph of the page 8. There is a door, my lord, in the middle of the first paragraph. My lord has found.
No, page 8.
Page 8, internal page 8.
Which paragraph?
My lord, page 8, my lord, the paragraph, 4 lines, my lord, from the first paragraph, 4 lines from there. There is a door on the southern side. My lord, the last paragraph of that page 8 is the learned advocate for the plaintiff. Page 8, internal page 8, my lord, got.
Internal page 8, last paragraph is. Yes, advocate for the plaintiff.
Yes.
After that,
from there, top, my lord, if my lord goes 1, 2, 3, 4, 5, 6, 7, 8, 8 lines top. There is a door on the southern side.
Show it in from your copy.
My lord, here.
Page 8 starts with of the godown is being used, reaching of the door.
No, my lord.
Second paragraph starts with the learned advocate for the plaintiff submits that the submission is made by learned advocate for the defendant. A different page.
71.
Commissioner নামটা কি দেখো?
Commissioner নাম?
Commissioner is Dinesh Kumar Soni.
Or parties.
Then Amarendra Goswami.
পেছন দিকে দেখি সই করে Kishori Mohan Pal.
Kishori Mohan Pal.
Yes.
Yes.
Lord, I just mark it. There is another copy, my lord. Mark it. Can
Pages are different. Yes.
Certified copy. Oh,
yes, maybe.
My lord, kindly takes this the same copy. My lord, another copy I was making ready for Mr. Mukherjee. There is a door.
Pages are not telling. Take this back then. There will be confusion otherwise. Refer to them. There is a door, yes.
There is a door on the southern side of the godown, which is for the ingress and egress to the godown.
Maybe.
Milord, there is a door, Milord.
Maybe there has to be a door to the godown also.
Which is situated on the western
No, please
side
come
of the
to page.
godown is used reaching up to the godown door. So, Milord, there is a passage, Milord, from the main road leading up to the godown. When around this premise, Milord, the trial court has held, you will not use that garage space.
See, please come to page 5, Mr. Chatterjee.
Yes.
Read point number D onwards of the local inspection. We don't know what was point number D, though.
Yes.
But let us read that. Please read that.
I found a main entrance.
Yes, from there, please read out.
I found a main entrance gate just in front of the suit premises facing northern side. The distance of the main entrance gate from the one pillar to another is 15 feet 2 inches, having one wing palla each side. After main entrance, I found a common passage measuring between 14 feet 5 inches east to west and 4 inches north to south. And I also found the passage cum space is situated in between the godown and the main gate, entrance gate.
Then
the space is under the roof and 2 bricks built step to enter into the godown. At the time of my inspection work, I found
it is very evident, Mr. Chatterjee.
No, but then
main entrance gate, distance of main entrance gate from one pillar to another is 15 feet.
Yes.
So none of these are 15 feet.
No, I'm saying it's 5 feet. Milord, it is 15. Garage is larger.
After the main entrance gate, I found a common passage cum space measuring 14 feet by 5 feet east to west and 14 feet by 4 inches.
Well, that is the bit.
That is that space which we are seeing.
No, Milord, the garage, only the garage.
No, he does not say garage.
No, Milord, that's why I said, Milord, if Milord carries on.
And I also found the passage cum space is situated in between the godown and the main entrance gate.
Now, Milord,
the space is under the roof and 2 bricks.
Kindly reads over this inspection report. Milord, it goes on to find out the garage space with a matador standing.
Mr. Chatterjee, I can specify that you will only be entitled to put a lock on the garage door.
Yes, garage. Because I say, that's why I say, Milord, on the other entrances, they have keys of their own and I am holding a key.
I won't interfere with this this injunction order which prevents you from putting any obstruction to the main gate by putting a padlock?
No, my lord.
You can only put a padlock to your garage.
Yes, that will do.
Yes, Mr. Mukherjee, do you have an objection?
Exact thing
Yes.
that they are trying to do. Why I say this? They don't have a separate entrance to the garage. The main entrance, the main gate is going into the go down. They want to restrict my access in a circuitous way, pending the ejectment suit. And they don't have a specific garage door.
But your page 135 picture shows there is a garage.
No,
The entrance is different.
No. Will kindly have a look at this photograph. This is a better.
No, the right hand side of that.
Yes.
This right hand side is a statutory, not the side space. This is not an entrance. Entrance is not what is covered by the blue door, which is 15 feet, according to the commissioner's report. Your lordship will see, the go down here at the back. This space is what the commissioner talks about. They are trying to lock these two doors by putting a padlock so that I cannot effectively use the go down. That is their purpose.
No,
my contention before the learned court was that you kindly do not block my access by blocking the main entrance door. They say now that you can take your goods from the statutory side space, which is not possible for a using the property as a go down. Now,
but then taking advantage of this, Mr. Mukherjee, you will be using.
Your lordship, the suggestion was the best because I could have restricted access through any of the vehicle.
You cannot park any. You cannot park any vehicle.
I cannot park. I'm not willing to park even.
No, my lord, only one.
That was not the best workable solution so that I survive. My learned friend also, if he wants to keep.
If he wants to survive.
Yes. No, my lord, only one thing.
Yes.
What has fallen from Mr. Mukherjee by ekbar chobita da. My lord, kindly says, my lord, this is the garage where the decree goes against his. My lord, he was parking this type of vehicle and my lord, disturbing my vehicle to be parked. Now, my lord, tomorrow if my vehicle is parked, my lord, he can use this passage and my lord, we have not obstructed this part. He can enter from this way and go this way. My lord, it's not that he needs to.
Continue hearing next Friday. It will take some time. We'll have to look into the paragraph. And the commissioner's report, please just hand over a copy to Mr. Mukherjee. It has to be a replica.
Photocopy of this part.
Yes, yes. A photocopy of this has to be handed over so that the pages.
Kishan Kumar Paul. Oh, Kishan Kumar Paul. Kishori Kumar.
After order record karo, heard in part, full stop during hearing, learned counsel for the petitioner hands over a copy of a commissioner's report filed in the trial court, which is kept on record. Full stop. A copy thereof be handed over to the learned counsel for the opposite party during the course of the day. For further hearing on.
The service may be kept
on February 21, 2025, push up, affidavit of service filed to be given. Yes, yeah.
Well, at the risk of being severely reprimanded, my lord, a contempt petition appearing as item 2 in today's list, my lord, out of pure inadvertence, my lord, attributable to only me and my advocate on record, we were not present, my lord. My lord has passed an ex parte order, my lord, finding there's a prima facie case of contempt made out, my lord, in that matter, my lord. Perhaps, my lord, if I've served notice, my lord, on the other side, my lord, they are present, my lord. If my lord gives me an opportunity to say one line, my lord, as to why that prima facie case of contempt can.
What is that line?
That one line is that, my lord, that person is a personal guarantor, my lord, and his personal assets have not been proceeded with. That is the only reason, my lord, respectfully, my lord, and with utmost humility, I
come back. We have not issued a rule. Come back and explain.
On 7th of March, my lord,
whenever, yes.
An affidavit of opposition direction, if my lord so permits. If not, my lord,
I cannot change my
very
order.
well.
You can come prepared. You can serve an advance copy. Then I'll direct you to file on that date and ask them.
Very well.
If you want.
My lord, the copy which I have handed over, can I take back and made a copy and.
Then again, the page numbers will
very
vary. No, if you personally have to assure that the same copy will come back.
That is the purpose he's asking for.
No. I shall do it.
The same copy as
That's right. Because it has tallied with
on record. But please ensure that it is returned within 15 minutes. এটা দিলে এই ফাইলে যেন ঢোকে
আমি এক্ষুনি দিয়ে যাচ্ছি